require any degree college under the policy of state government or not. Learned additional government advocates shall also be required to seek instruction as to whether the institution in question impart education for award of degree or not. Please, this matters once. Today I have filed the instruction which I have received from the higher education
You don't file
department.
instruction, you file that on affidavit.
No, your lordship has asked me to just submit the instruction. You will take this.
He has just showed me a copy of a letter,
That
and I've
instruction-
also replied.
That is very
All
specific.
distorted and misleading.
He files an instruction, you file a reply. So neither his instruction nor your reply can be taken on record. File your affidavit.
Well, let them serve a copy, my lord.
What?
I am for the Union of India.
Union of India has nothing to do.
All right, what is your stand?
Yes, your lordship may see that for a while. Your
No,
lordship-
just
yes.
instruction means just to assist the court.
Yes,
This is what you have been told and
Nah,
you can convey that to the
The
court.
instruction letter reveals that whatever instruction I have received, that is already there in the counter affidavit. That is also,
All right.
your lordship may see page 2.
So nothing beyond the counter affidavit.
Nothing beyond. Only one thing, whether your lordship has asked me whether this particular institution will in future
In the
impart any degree-
locality, whether
locality. That is there in the counter affidavit. Still, I have reiterated in this letter.
this is centrally funded institution.
Yes, my lord.
The central government funds 60% and state takes 40%.
Whether there is any degree college nearby the locality and whether this is necessity for using it as a degree college. That was the query. Just I am just placing one paragraph of that letter. In this query, it is mostly submitted that to meet the educational need of the area in question on the score of higher education, there is an existing general degree college which is situated nearby of the model degree college. That is the subject matter of this case. Constructed by Higher Secondary Education K. Nwaka, Mauja so and so, and the said general degree college, namely Kandhamala Degree Mahavidyalaya, is running at Saragaria in the same K. Nwaka block in the Kandhamala district. So far as the status of the existing degree college as cited above running in K. Nwaka block, sanctioned student strength is 736 and the submitted student strength is 540, leaving 196 seats fallen vacant. It is here felt apposite to submit that if the Kandhamala district is taken as a whole, there are 20 numbers of degree colleges, government, non-government, aided and unaided education colleges, which are existing with student capacity of 14,928 and students got admission against these seats is 10,561, which shows that capacity of the existing running degree colleges in the district of is enough to accommodate the educational need in the sector of higher education in the aforesaid district. So also, if the case of Kenwaga block is taken into account, it also shows that in view of the huge number of vacancies against the sanctioned seat, there appears no further need of opening another colleges. Considering the above, it was decided to hand over the building to SD and TE department to run skill development center with a motto for skill building and to enhance employability among the youth mass. Pursuant to kind orders of the Honorable Court, dated so and so, it is most humbly submitted that the institution in question, model is so and so, having been handed over to the SD and TE department, no general degree education is now imparted to the students for award of degree in this sector. These are the two questions and these are the two answers.
I have filed a reply affidavit, my lord. Whatever my learned.
Mr. The whole difficulty is that you cannot file reply to the instructions which he has received. All right, if you
Since
have to.
showed me a copy, I thought it probably I have filed. In any case, your lordship may consider.
Have you filed affidavit?
Yes, yes.
File the reply on affidavit.
Yes, yes.
All right, we'll see.
Here, my lord, he says that there is a nearby college. There is no such nearby college. The distance is next nearby college is 18 kilometers, 15 kilometers, 26 kilometers, and 30 kilometers I have given. And the criteria fixed by state government is that if there is no college within 10 kilometers, there has to be a degree model college. That is additional affidavit earlier filed. I have given the criteria.
No, whether this fact you had mentioned in your writ petition.
Yes,
that
not
10
in reply
kilometers.
affidavit. Yeah, writ petition I have stated categorically it is beyond 15 kilometers.
Where is that?
In the writ petition,
Page 9, 4.5.
minus. Yes, madam. 4.5. Decision of the source of building constructed in the purpose of model degree college so and so created high discontentment among about 25,000 villagers at K. Nuagam block, Kandhamar, who are being deprived of getting the scope of a degree college within 50 kilometers of the vicinity. For such reason, the villagers, including the president, so and so.
And where is the policy?
But the policy additional affidavit, my lordship, Annex 8, additional affidavit dated 4/8/2024 that I filed,
4/8/2024 has not reached.
that is there. Sorry,
Flag D.
8/4.
Yes.
Additional affidavit, my lord. Today I filed the second copy of it.
Yes.
That is Annex 8, my lord. At page 5 of the affidavit, the criteria, lordship, may straight away come to serial number 2. The location of the college must be such that there exists no other college in the radius of 10 kilometers. And the next also, location with predominant rural population is preferred. This is admittedly a rural population having social and educationally backward.
What is his reply? What is your reply to this statement?
He said nearby only.
No, you have to.
No.
What is your reply
My
to
lords, I'm just.
paragraph 4.5?
Paragraph 4. Page 4, paragraph 8. That counter affidavit of additional secretary to government, higher education department.
Yes, paragraph
8. It is humbly submitted that since there is an existing general degree college situated nearby wherein the sanctioned student strength does not get fully fulfilled,
Sir, that is not the question. The question
Yes.
is there
10
is
kilometers.
specific government.
After your counter being filed, we have passed an order requesting you to take instruction whether there is any nearby locality it is necessary for degree.
This
model
counter
degree
affidavit
college.
is in consonance with the instruction which I have filed today. But so
So
far as
you are
that
not
10
specific in your
10 kilometers part.
yes.
You will
That
have to address. And you are evasive.
I will file a small short affidavit on this.
There is specific government in the writ petition in paragraph 9 of the writ petition to, paragraph 5.5.
Page 9.
Just
4.2.
4.5
4.5.
of the writ petition, which reads thus. First off, when counsel for the petitioner has drawn our attention to a letter issued by the Higher Education Department, Government of Odisha, dated 31/5/2018, bracketed annexure 8, which 8 in relation to establishment of model degree colleges in aspirational districts of the state under centrally sponsored scheme Rashtriya Uchchatar Shiksha Abhiyan, bracketed RUSA 2.0. Clause 2 of the said letter reads as under, colon dash, quote, the location of college must be such that there exists no other college in the radius of 10 kilometer. Full stop. A counter affidavit has been filed on behalf of the state
Higher Education Department.
on behalf of Higher Education Department of the state. Where is the reply?
Para 8.
Para 8, you have not, this is not a para-wise reply. In the counter affidavit, the government made in paragraph 4.5 of the writ petition has not been controverted. First off, the petitioner's case in relation to the existence of the said policy, namely RUSA, is also not in dispute. RUSA 2.0 is also not in dispute. Full stop. It is unfortunate that the state has not cared to specifically deal with the government made in the writ petition. Government made in paragraph 4.5 of the writ petition. Full stop. We direct who has filed the counter affidavit?
Additional Secretary.
And we direct the additional chief secretary?
No, Additional Secretary.
No, he has filed.
Additional Secretary to Government.
Who heads the department?
The Commissioner cum Secretary to Government.
Secretary, we direct the Secretary, Government of Higher Education, Higher Education Department, Odisha, to file an additional affidavit dealing specifically with the statement made in paragraph 4.5 of the writ petition. Be careful, this is not done.
May I pray, my lord? Last occasion, lordship directed to serve with the copy of the counter. They have also not served upon us.
Is there any rule? Is there any rule
But
that
being a party, my lord, opposite
we
party,
are putting this question, Mr. Counsel, whether the High Court rule provides that every party should be served with a copy of the every pleading?
as a practice, my lord, they should provide, my lord. My lord,
examine-
the scheme is sponsored by central government, my lord. They are now altering that scheme to some other project. They cannot, my lord. As because after approval, it has been sponsored.
All right.
Yes, my lord.
So tell us,
What
whether-
stand they have taken, we are in blind, my lord.
Sir Counsel, have you examined the rules, High Court rules? Whether the High Court rules provide that respondent, opposite party should serve a copy on you of his pleading. What will you do with his pleadings? Have you filed counter affidavit? Why have you not filed?
My lord,
You could have supported the petitioner's case. You will depend upon the stand which the state government takes.
what they are taking stand, my lord, we should be aware of that, my lord. They are not, sir.
Take, he is your colleague, you can.
Your
take a
lordship
copy from-
directed. Your
No,
lordship
no
di-
judicial order.
Last occasion, your lordship directed.
No, we are not. Reply we will file later. There is no reply.
In that reply, I will enclose this instruction. In that affidavit which I will file, I will also enclose this instruction.
Which instruction?
This
How can-
instruction is also evasive.
I will explain this fact which I have stated.
We are not taking instructions on record.
Yes.
Counsel, instruction is only for the purpose of assisting the court.
I will explain it in my affidavit, which I will
You
file.
can do that.
Yes.
That's why we have observed that you have taken evasive.
See, so many things you receive as instructions. Everything you don't share. Sometimes you get material instructions also. All the instructions are not to be shared.
Not this.
All right, yes. 2 weeks?
2 weeks.
2 weeks.
My interim order to continue.
Interim order shall continue in the meeting.
Item number 2.
Item 2. Lordship may pay, Lordship take it over at 2 o'clock.
Yes.
Okay. Item number 3.
May I please, Your Lordship? May I please, Your Lordship? My Lord, here I have challenged the order of the Honorable Single Judge, whereby, though my Lord, direction has been issued that my claim for settlement of land should be considered, but the protection has been granted only for a period of 1 month. Thereby, I am, my Lord, now subjected to eviction, though I don't have a land, and a certificate has been issued by the government, which shows that I
Where
am
is the order?
But the
Pastor.
order is at Annexure 7, page 37. It commences from page 37. And with your Lordship's kind permission, I'll just draw your Lordship's attention to page 41. Page 41, from the top para last 5 lines, as a necessary corollary, the decision of the opposite party number 2 by Annexure 5 subsequently confirmed by Annexure 7 has to be held justified and in accordance with law. In other words, the court is of the view there is no legal infirmity in the impugned order under Annexure 7. I'll pause here for a moment. These orders were passed in exercise of power under the Orissa Public Premises Eviction of Unauthorized Occupant Act, which is applicable to the municipal areas on the ground that I have occupied a government land. And that was considered to be a premises and eviction proceeding was initiated. Thereafter, your Lordship will see, however, considering the submission of Mr. Bhuyan, learned counsel for the petitioner and a request for a reasonable time to vacate the scheduled land, the court is of the considered view that the ground upon which the allotment of the government land is claimed, for which is on the strength of Annexure 2. Annexure 2, I will show to your Lordship. Liberty should be granted for him to pursue and demand for such allotment, approaching the authority concerned until such time possession in respect of the scheduled land should be protected. So the court feels that since there is already
No, that is submission.
that's a submission. Thereafter, your Lordship will see the
Para 9.
direction. Paragraph 9. My friend for the state may bear with me for a moment. In the result, the writ petition stands dismissed as a logical sequitur. The impugned order under Annexure 7 is
Paragraph
hereby
7 is not submission. The observation based on your submission.
Paragraph 9 is malady observation.
Yes.
Well, so also the order under Annexure 5
No,
by
paragraph 7 is also observation.
I
Observation
stand-
in the light of your submission.
I stand corrected. I am obliged, my lord. I am obliged, my lord. My lord, so far as paragraph 9 is concerned from line number 4, however, the court directs the petitioner to pursue the matter seeking allotment of government land on the basis of a claim by the Annexure 2 if a request is received from him, which shall be considered by the authority concerned subject to eligibility and entitlement as per law. For the said purpose, 1 month time is allowed. It is made clear that if so no such allotment of government land is made or could not be considered within the above stipulated period, the petitioner shall immediately vacate the scheduled land, failing which the appropriate legal action shall follow pursuant to Annexure 7. My grievance is this. Your Lordship will kindly turn to Annexure 2. This is in Odia, it may be pardoned, but one thing your Lordship will consider, therein the statute has been mentioned under which this certificate has been given. But there is an act enacted by the state government, that is Orissa Land Rights to Slum Donors Act. Now, with your Lordship's kind permission, I am producing the statute in full, which I have got copies for your Lordship's kind perusal. Here, what happened? The state government recognizes the slum areas in urban areas, and they give a certificate of entitlement of allotment, and the area to be allotted has been provided in the statute itself. Annexure 2 reveals that I am a slum dweller and I am entitled to an allotment.
But in view of this, your submission as noted in paragraph 7, what remains?
My only thing is that your Lordship will kindly consider.
But
The
the
court feels that I should be protected for a period till my allotment aspect is considered. Here, there is an admitted document under Annexure 2 which shows that I am a slum dweller and that means I am not having any house to reside thereby, and they recognize it by issuing a certificate, which is being done as per this Odisha Land Rights Act, which I have just produced before your lordship, by conducting an inquiry, because they identify, then issue a certificate.
So did you bring this fact to the notice of the Learned Single Judge?
Honorable Single Judge has taken note of that. Annexure 2 means this Annexure 2. So my only grievance is, my lord, that till that is decided, because they have to give me a piece of land somewhere to reside, I may be protected. I am not seeking beyond that. But if I am thrown out now, then I am nowhere, my lord. That is the only grievance, nothing beyond that, my lord. Since the Honorable Single Judge thought it proper that my application should be proceeded.
Where is your certificate that you are a slum dweller?
That is Annexure 2, your lordship. That is page 26. This was before the Honorable Single Judge also. Therein, your lordship, they have mentioned in Odia, Odisha Basti Basinda Bhumi Adhikar Niyam, that I have produced before your lordship. That is Odisha Land Rights to Slum Dwellers Act 2017. I have produced just now. And they have also formulated a set of rules to work out the modalities. And this is how they have recognized. This is their document. So therefore, till they decide my fate, I am only saying till then I may be protected. Let them decide, because they have recognized me as a slum dweller. This is the Yogyata Pramana Patra. That means this is the eligibility certificate. And they do this after conducting an inquiry under the statute they have enacted. So this is my limited.
What is there in the rule?
The act I have produced. Then with your lordship's permission, I am also producing the rules. That is slum dwellers rules they have also formulated.
Which provision?
The provision I am pointing out to your lordship from the statute. My lord, your lordship may kindly turn to page 5, section 3. Definitions are there in section 2 with regard to slum dweller and other things. Then they say, notwithstanding anything contained in any other state law for the time being in force and subject to provisions of subsection 2, every landless person occupying land in a small slum in any urban area by such date as may be notified by the state government shall be entitled to settlement of such land, and a certificate of land right. This is the certificate under Annexure 2. Shall be issued in accordance with the provisions of this Act. The land shall be settled in favor of a slum dweller to the extent specified hereinafter. Then they have quantified how much is to be settled. Then economic weaker section category, how much he is entitled to, and all those modalities has been spelled out.
That is a different procedure altogether in a different provision.
I am not disputing that.
You may claim.
I have claimed. The court says your claim may be decided,
Yes.
but protection is only for 1 month.
Yes.
So if I am thrown out before that, my lord, I remain nowhere. That's my grievance.
Very difficult.
I am only saying till they decide, let them decide immediately.
Have you made any application, or is there any application required?
But this is not, application is not required. This is the recognition they have to give me. That's all. As per the statute,
When
recognition.
was this recognition given?
Recognition, my lord.
Recognition was given to you when?
That is, my lord. That, my lord, your lordship will consider. They have put a house number, everything, but that date is not legible where the authority has signed, the municipal authority. But this document, genuinity is not in dispute. That has been taken note of by the Honorable Single Judge.
I want to point out one thing from this annexure to your lordship may kindly have a glance. This is Rekharani Mahapatra, ward number 18, Jamuna Deipur, Bikesipur.
Yes.
Lordship may, ward number 18 of Rekharani Mahapatra. Lordship may see the cause title and the affidavit of the petitioner. Rekharani Mahapatra, ward number 17, Bolarampur, PO Bhanipur, PS Baripada.
I am not disputing that. Let me answer.
That certificate is in respect of a land situated in ward number 18 of Baripada town, but the petitioner claims to be the resident of ward number 17 of Baripada as per the affidavit given in the writ petition. And add to it, your lordship,
You place the note.
My-
Note. Drashtabhya.
yes, and that is what I am just saying. Jodi apna ajogyo jamire rahuthanti apanako anyo avasyogo bhumi adhikar pramanapatra pradan karajibo, and everything the adhikar pramanapatra pradan karajibo, it will be given to you. Not that this is a certificate acknowledging that he will come under this particular act. It will be given subject to verification.
That's what I am saying.
And this is for ward number 18. You are a resident of ward number 17. how can you correlate this certificate to the petitioner who is a resident of ward number 17 according to your own affidavit? So my resolution submission is that
And
this
this land this land is of what nature?
My lord, may I just,
Where you are going to be evicted?
may I just humbly explain? This land where I'm in occupation is a government land. And let me clarify, I have annexed the pota.
You were using that land for what purpose?
Residence, I'm staying there.
So you are residing there and you are residing in a slum. Where were you residing?
No, I am residing in the land which is mentioned in the cost title, which area I have mentioned, which my land friend for the state was pointing out. They have said that this land is slump area is identified to you and you are eligible to get it. So therefore, which my friend is saying that two different areas is not correct.
yes.
I am sought to, let me just clarify. I am sought to be evicted from an area which I am occupying and I is having a house in ward number 17, whereas
Is that a slum area?
slum area is ward number 18, where I have been identified to be allotted.
Council, Senior counsel, the place from where you have been directed to be evicted is a slum area.
No,
All right.
that's a municipal area.
Municipal area.
Ma-
So you are not living in the slum area from where you have been directed to be evicted. Now
No.
you claim,
I am not directed to be evicted from a slum area. Your lordship is right.
no, you have been directed to be evicted from a government land. So you are not residing in the slum area when the order was issued, the order was passed.
No, I was not residing.
Then
I have been issued with a eligibility certificate.
you claim you.
Ma'am, may I just humbly clarify?
Sorry, sorry.
I have been issued with a eligibility certificate.
Sorry, it's a government land.
I am only praying for a protection
not-
till my
not
fate
even
is
a second.
decided.
Not even for a second.
Now, this is the difficulty, my lord. This is a residential house I am staying. I'll be nowhere, my lord.
Yes, you enjoyed. How many years did you live there?
I have no other land.
Yes,
They have made a
so many
provision.
people have no land.
Ma'am,
But you had the advantage of occupying.
even
government land.
in
Sorry.
Katak, your lordship will see those persons who are.
We have to examine the legality of the.
May I just point out one thing for your lordship's consideration? Your lordship has seen in that paternal area where they wanted that they should beautify it by evicting those slum people. They have given them land near Trisulia by constructing a building in subsidized allotment.
You also made.
So here also they have made a provision for me to be allotted.
How many years did you live in this area?
I have been living since
In that building, in the government premises?
government premises, my lord, that is that's my lord, since 90s, my lord.
You should be evicted today. This is the order which.
Your lordship will consider, they consider that they should be protected.
No,
The government
You
consider.
have taken a risk of filing this appeal.
My lordship
No.
considers whether this is.
Sorry. It's too much.
As your lordship please.
The this intra-court appeal has been filed by the appellant assailing an order dated in extra 7. By order dated 31/1/2024, passed in WPC number 24338 of 2023. Dropped. The said writ application was filed by the appellant putting to challenge an order passed in what is OPP?
OPP, Orissa Public Premises Eviction of Unauthorized Occupant Act.
OPP bracketed EUO full form
Eviction of
Appeal case
unauthorized
number
occupants.
2 of 2022, confirming an order passed by the Tahsildar cum State Officer Baripada in OPP EUO case number 9 of 2022. Full stop. The क्या हो जाता है इसमें? ये necessary not moving. What is the defect?
Tahsildar's order has been confirmed by the collector by Annexure 6.
Let us see the order. Seems that the system is not working. चलिए। The appellant was found to be in unauthorized possession of a government premises. Government premises,
Mine.
public premises.
Public premises, that's the
Public
language.
premises. By the order passed by, in the order passed by the Tahsildar, which came to be affirmed by the appellate authority. Stop. From the impugned order passed, a single judge has affirmed the concurrent findings recorded by the Tahsildar and the appellate authority as regards appellant's occupation of the public premises without public premises unauthorizedly. Stop. An alternative submission was made before the learned single judge, which has been considered in paragraph 7 of the impugned order, which reads thus: alternative submission on behalf of the appellant. Stop. Learned single judge, after having dismissed the writ petition, directed the petitioner to pursue the matter seeking allotment of a government land based on a claim that he had a certificate of being a slum dweller. Full stop. Next. Slum dweller. Then single judge also observed that if any request was received from the appellant, the same shall be considered by the authority concerned, subject to the appellant's eligibility and entitlement as per the law. And for the said purpose, 1 month's time has been allowed by the learned single judge. So stop. Next. Learned senior counsel appearing on behalf of the appellant has submitted that the impugned order passed by the learned single judge be modified to the extent that till the appellant's application for settlement on the ground that he was settlement of land on the ground that he was land under the provisions of Odisha Land Rights and Slum Dwellers Act, 2017 is decided, he should not be evicted from the public premises in question. Full stop. In response to a query made by this court, then senior counsel has informed that the petitioner was in occupation of the said public premises for more than 30 years.
Man.
Full stop. The question as to whether the appellant can still be considered to be a slum dweller as in occupation now was residing. The question as to whether the appellant can still be considered as slum dweller after having stayed unauthorizedly in a public premise in question for more than 30 years can be decided by competent authority while considering his claim for allotment of land under the provisions of Odisha Land Rights to Slum Dwellers Act 2017. Full stop. We do not find any requirement in the present intra-court appeal to interfere with the impugned order passed by the learned single judge, even by way of modification as sought for on behalf of the appellant. This appeal has no merit and is accordingly dismissed.
Man.
For your lordship's observation, we are filing.
The instruction to execute from the response number 1. Against an interim order is comes. The case is dismissed. And filing a power, request my friend if you saw the copy of his writ appeal so that I can have a.
Now let us see what is the interim order.
Yes, that the. Page 333.
Annexure.
That annexure 10 at page 330. That this employee is going to be retired today. And the interim order has been passed at page 333. Considering the stand, well, as you got it.
Page 33.
Page
Annexure 10.
333.
333.
Yes.
So which post you are holding?
That's holding the post of senior student activity sports officer, SAS officer, which is a non-teaching post, and he is coming to a non-teaching faculty cadre, and the age of retirement is 62 till today. Another employee having the same status approached this honorable court earlier in 2018. This honorable court rejected the interim application by saying that the retirement is subject to the result of the writ petition. That writ petition was also tagged with the present writ petition before the honorable single judge. And that writ petition is pending. My learned friend, I have filed the counter. My learned friend has filed a rejoinder, and that is pending for disposal. At this juncture, this writ petition was filed by another employee on the verge of retirement, on the month of retirement in the March. And we were directed to file the counter. We filed the counter on 6/4, and the matter was directed to be listed on 8/4. Thereafter, my learned friend has filed a rejoinder, and the matter was posted to 23rd. My lord. On 23rd, I was arguing a matter before your lordship, my lord, that revenue matter. Your lordship fixed up it to 2 p.m. So therefore, I was on my legs before your.
That's different.
Yes. So the Honorable Single Judge has passed this order when the pleadings were completed, and another writ petition, the order was passed that the retirement is subject to the result of the writ petition. And when an order of retirement, termination, and other things have been challenged before any court of law, normally the court should be reluctant to pass an entry order.
Yes, that's right. He is ready to pay everything if your writ petition is allowed. He is giving an undertaking. Are you giving?
Yes, my lord, I have just
Yes.
today.
He has given an undertaking.
I give a undertaking. Now, my lord, the case is posted to 13th May. Let there be a perimeter hearing.
No, that
I
is not
give
the
an
question.
undertaking.
The
My lord.
question is that if his writ petition is finally dismissed,
My lord,
then
I will
what
not
will
claim
happen?
any benefit.
Huh?
Let me continue. I will not
Why
claim
should you
any benefit.
continue?
I will claim.
This is the question which we are putting.
My,
That if your writ petition is finally dismissed,
my,
then why should you be allowed to continue?
my lord, on this aspect, I will only 2 lines from the
So,
what his submission is. I have understood, my lord. Though I have not got the copy. What he says, this physical education personnel are not the teaching post. Therefore, they are
we are not going into the merits.
Yes.
We are not at all going into the merits. The question is, according to them, he should have retired from today. From today?
Yes, ma'am.
He should have
Today.
retired from today. According to you, he should retire after
3 years.
3 years. Now, there is dispute which is pending. The institute is ready to pay everything. If finally you succeed in the writ petition, they are filing an undertaking. You are not entitled to anything more than your allowances, your all benefits.
That's
So that we can clarify.
only one more addition to this. I will avoid for this. If my friend will undertake, he will cooperate in the hearing.
Yes, yes.
Because now kindly
Yes,
see
yes.
when the
Yes.
order itself,
This we
the
have
order
to-
itself, he has taken time.
No,
And
no.
on his BS, because it was fixed for a preliminary hearing. Because I am to retire today, my lord have fixed to, Honorable Single Judge has fixed to 23rd. It can be hard and dispose of whatever the result is.
Yes, yes.
On that date, on his request, the case was adjourned. So that is why I placed the case on merit also. The Honorable Court has granted, yes, you have a prima facie case, so granted that he should be allowed to
So
continue.
only this.
That is
this
the point,
modification-
that is the only point.
modification. Yeah, well. Only this
I
modification. This will prejudice none. If we modify the order to this extent, this will prejudice none. Because he will be,
Your your prayer in the writ petition is
Yes,
this same thing as the.
as the interim order granted.
No, and prayer is up to, continue up to 27, 30. 34, 27, my prayer is.
what is the post?
That is senior student activities, sports officer and sports officer. Date chart. I am submitting a date chart for your lordship's.
No, not. What is the,
Post is
according to you, he is holding a,
According to me, he is a
Non-teaching
post
post?
holding a non-teaching.
I
post.
am, according to me, it is a teaching
And the-
post as per the statute.
you have said
that
that
much.
the post is
Teaching.
student activity and sports officer.
And sports.
Yes,
officer.
yes. Now, my lord, the background,
Please.
just we are recording. now.
Student activity and sports officer.
yes.
That is the post.
Now they have nomenclature.
So he is attaining his 62 years today.
Today.
As per policy of the central government,
60,
the
65 years.
teaching post,
62.
teaching post,
65 years.
Teaching post
teaching
65,
post 65.
non-teaching post 62.
And what is the name of the appellant?
Dr. Tushar
National
Ranjan
Institute
Patnaik.
of Technology.
No,
Appellant-
appellant name is Dr. Tushar Ranjan Patnaik.
No, you are not the appellant. You are the
That
petitioner.
National,
sorry.
National Institute of Technology, Rourkela. NIT Rourkela.
NIT the National Institute of Technology, Rourkela, has filed the present intra-court appeal against an interim order passed by a learned single judge of this court dated 23/4/2024 on IA number 4212 of 2024 in WPC number 2763 of 2024. Stop. The impugned order reads thus. Stop. The writ petition was filed by the respondent with the following prayer. Stop. This is IA or what? No, this is IA. Prayer in the writ petition.
But prayer in the writ petition is
There's 10 of
Is
the.
it?
Dej.
I'm just,
Dej.
30, page 30.
Without prayer.
But prayer in the writ petition is at page 30, Mila. Page 30 of the in the writ appeal.
No, writ appeal.
Writ appeal
Page 30.
is internal page 30.
Acha. This is item number. So, precisely, it is the respondent's case that he is working against the post of senior students' activities and sports officer in the NIT, which is a teaching post. First off, it is the stand teaching post. The age of superannuation for a teaching post in NIT is 65 years.
Well,
Whereas that of a non-teaching post is 62 years.
62.
Stop. If the respondent is treated to be a person holding non-teaching post, he would be superannuating with effect from
Today.
today, bracket date. Stop. It is in that background, learned single judge has passed the interim order directing, impugned interim order directing the NIT to allow the respondent to continue in the meanwhile. Next. Learned counsel appearing on behalf of the appellant has submitted that passing of this aforesaid interim order amounts to allowing the writ petition itself, allowing, granting the relief which was sought in the writ petition. So he has filed an affidavit on behalf of the NIT stating that undertaking is there. Where is that?
That para 3 I expect. Para 3 of the undertaking. para 2. I'm sorry. That is stated here that in the event the prayer made by the petitioner in WTC
Stating
number
in paragraph
2.
2 as under. Full stop. Next. In view of the undertaking as given in paragraph 2 in the today's affidavit, comma, we deem it proper in the interest of justice to modify the impugned order passed by the learned single judge to the effect that in case the respondent succeeds in the writ proceeding, comma, he shall be entitled to all benefits, all consequential benefits in terms of what? In terms of salary, emoluments, allowances,
Everything we have admitted.
all consequential benefits.
Only
That's
one prayer. In the, because today he's retiring, he's holding a quarter. Let it not be, he not be evicted, at least for that
Is
purpose.
difficult. That is difficult. That you will be entitled for HRA.
But the 13th is the date fixed. 13th, only
13
this
is
was
the-
because they're behind this person. That is why I'm requesting, madam. Otherwise, I should not have. Let
Whether-
him use that
whether-
good of his also.
Just a minute, whether the pleadings are complete.
Yes, my lord.
everything is-
Pleadings are
plus-
complete. Everything
plus-
complete.
plus for hearing.
So we will give
13th
you,
is-
how, what is the,
13th is the date.
you can retain the quarter even after retirement for some
For
time.
1
Yes,
month,
yes.
my lord. That is the,
One
that
month
the
you are
rule.
entitled to.
That is the rule. They will
Because
not evict it.
13th is the date fixed.
That order can be passed.
Yes,
To that effect, the order can be passed by the learned single judge.
That-
Just a minute. Learned counsel representing the respondent has submitted that the respondent is occupying the official residential accommodation provided by the NIT. First off, if he is treated to have attained the age of superannuation and retired, the institute may take steps for his eviction from the said premises.
Hmm.
So he accordingly submits that this court may grant some protection in this regard. First off, we are not inclined to accept the aforesaid submission for 2 reasons. First off, firstly, the respondent, firstly, it has been stated at the bar that he is entitled to retain the said official accommodation for a month
for a month.
after the
After
the date of superannuation, after the date of retirement. First off. Secondly, comma, if the respondent finally succeeds in the writ proceeding, he shall be entitled to house rent allowance also. If evicted from the said premises. Official residence. Stop. Thirdly, comma, it will be open for the petitioner, for the respondent to take such plea as can be taken before the learned single judge in this regard. Stop. With the aforesaid direction and observation, and with the aforesaid observation, the impugned order passed by the learned single judge is modified. This inter-court appeal stands disposed of.
Highly obliged.
Writ petition will be placed on the date fixed.
That is fixed on 13th. That will be
13th date.
We shall not observe that.
That has already been
There-
fixed to
that is
13th.
That is there on record.
That has already been fixed to
No,
13th.
we were going to observe that if you want to delay, you should not do. That is,
I will not,
that can be taken care of by.
because this is the reason, totally unavoidable reason the prayer was made. But what view your lordships was expressing, why this type of interim order should not be passed. But Honorable Justice Sabarwal has given the reason. Your lordship can see for a moment paragraph 8. Paragraph 8 of that full bench judgment. Paragraph 14. Paragraph 14, your lordship can see for a moment. Yeti. Only paragraph 14.
That is the logic.
Yes.
That
That is the
because
logic.
the vacancy has to be filled. Some persons may be promoted.
Promoted.
So these are and that is not going to prejudice you in any manner.
Anyone.
And sometimes, Mr. Such interim orders are also passed for the reason that you don't avoid court proceeding.
Yes, my lord.
We can
That is the
understand.
whole purpose. But
We can understand.
my lord, on that date, my lord, I was on
Alright,
my
it
next
happened.
before your lordship. On 20. My lord, urgent copy. Urgent copy.
Yes.
Item 5.
Item 5, Lordship, on behalf of Mr. Panda, Lordship permitted to.
Yes.
Lordship, on behalf of Mr. Panda, permitted to place.
Yes,
this matter,
yes.
Lordship. In fact, Lordship, I have come for restoration, Lordship, on the relevant day, matter has been dismissed. On the ground that intentionally, Lordship, deliberately, I could not remove the defects. But Lordship, matter is so urgency, and Lordship, in the meantime, in fact, Lordship, we had obtained the certificate copy and we have already furnished the certificate copy before this honorable court.
Where is the order?
Lordship, order dated, Lordship.
You have not annexed.
29/2/2024, Lordship.
You have not annexed the order.
Lordship, I have not annexed, Lordship, I have quoted the order at page 4, Lordship. Page 4 of the petition, Lordship. 29/2/2024, Lordship.
You did not remove the defects.
In fact, Lordship, that is, sorry, Lordship, for that, but we, in the meantime, we have submitted the certificate copy, Lordship, that is copy, Lordship. That is before registry, Lordship. We have already furnished certificate copy.
When?
Lordship, that is on Lordship 5/3/2024, Lordship.
So after dismissal.
Lordship. In fact, Lordship, there is a communication gave the certificate copy was with the advocate, Lordship. But that is due to fault of the advocate, Lordship. Client should not suffer, Lordship. That is admittedly, that is our fault, Lordship. We have purchased the certificate copy, but it could not be furnished due to some communication gap, Lordship. And immediately after passing order, we have furnished the copy. On the relevant, the advocate agreed.
By an order dated 29/2/2024. WA number 538 of 2023 was dismissed for default, noticing the fact that despite several opportunity granted by this court, the appellant had failed to remove the defects. Learned counsel appearing on behalf of the petitioner. This application has been filed for restoration of the said writ appeal to its original file. Stop. Learned counsel appearing on behalf of the petitioner has submitted that failure on the part of learned counsel for the appellant to remove the defects was not intentional, and because of certain unavoidable circumstances. So considering the facts and circumstances, this application is allowed. Let WA number 538 of 2023 be restored to its file, original file. Yes.
Lordship, grateful, Lordship.
Item 6.
Item 6, Lordship, kindly, the order dated 4/4/2024.
Yes.
Lordship, in fact, the petitioner challenged the tender call notice, but in view of para P, Lordship, view taken, Lordship, it can be treated as a PIL, a public interest litigation. Had it been a case, Lordship, PIL, then definitely in compliance of Rule 8, I have to approach before the authorities. And straight away, Lordship, I have come because I had challenged the tender. Lordship, kindly grant me report that I can file a representation with authorities, and so
We
that I can come back, Lordship.
We will not say anything. We will say that you may pursue.
Lordship.
You will not say that representation, file representation and dispose it of within 3 months. That we will
No,
not do.
Lordship. So only Lordship report so that I can come back, Lordship.
By an order dated, just a minute,
Lordship.
by an order dated 4/4/2024, passed by a coordinate bench of this court, the present writ petition has been treated to be in the nature of public interest litigation. What's up? Next, learned counsel appearing on behalf of the petitioner has submitted that the requirement of, which is that rule?
Rule 8, Lordship,
Rule 8
of the High Court PL.
of. what is
High
the
Court
name of
PL
the
rules.
rule?
Odisha High Court.
Odisha High Court PL. rules.
Odisha High Court Public Interest
Page 180.
Litigation,
2010. 2010.
2010.
the rules 2010, the petitioner has not. You understand? The learned counsel for the petitioner has submitted that there is no compliance of Rule 8
8.
of Odisha High Court Public Interest Litigation Rules 2010. Full stop. He accordingly submits, seeks permission to withdraw this writ petition with a liberty to approach competent authority for the redressal of the grievances.
Lordship.
Stop. This writ petition stands disposed of as withdrawn with the liberty as well.
Lordship. Grateful. Lordship.
Item number 7.
Yes.
But last occasion, this matter has drawn your lordship's attention about that land reforms.
Yes, I remember, and
Yes,
quite disturbing.
I would rather suggest, pray your lordships, that the matter may come up after vacations, so that in the meantime, what I was given to understand, the government is also contemplating to file, to challenge that order. So if
All
that will be there, things will be sorted out.
The
Let it come after vacations.
as requested by learned senior counsel, let's this matter on. After holidays का कोई Item 8.
This writ application, the petitioner seeks to challenge the amendment Orissa Engineering Service Method of Recruitment and Condition of Service Rules 2012 amendment in 2023, my lord. Lord, your lordship may kindly turn to page 47 directly, my lord.
Annexure.
Lord, Annexure 1, my lord. This is the base rules, what was prevalent earlier, my lord. Page 47, my lord. Rule 6. Has your lordship got it?
Yes.
In order to be eligible for direct recruitment to the post of assistant executive engineer in the service, a candidate must satisfy the following conditions. Namely, he must be a citizen of India. B, minimum educational qualification. He must have possessed a degree in engineering or an equivalent qualification from any university or institution recognized by the government, or he must be an associate member of the Institution of Engineers of India. Then when your lordship skip the rest of the things and come straight to page 48, my lord. Rule 7, my lord. Has your lordship got it?
Yes.
When the government decides to fill up the vacancies in the post of assistant executive engineer by direct recruitment, government will communicate the number of vacancies in the post along with reserved vacancies thereof proposed to be filled up. The commission on that is Orissa Public Service Commission, my lord. Commission on receipt of the requisition shall in such manner as it thinks fit shall invite application from eligible candidate. The commission, after receiving all the application, shall take steps to select candidates in the manner given below, my lord. My lord, that is written test, objective written test, and vice. Now, my lord, by amendment act of amendment of the rules in 2023, my lord, what happened, my lord? The government wanted to do away with the entire Rule 7 and substitute it, my lord, by placing that it will be selection will be on the basis of gate score. Totally.
What is wrong?
The method of selection, Rule 7 is the method of selection. My submission is that one, that the method of selection cannot override the eligibility criteria. But it is as good as saying that if the method of qualification, gate qualification is a eligibility test for getting admitted into higher courses. If the eligibility criteria is engineering, we are all qualified engineers, and you prescribe a qualification, supposing the eligibility criteria, I am giving an example, my lord, and ponder over it. Lord, that eligibility criteria is...
This is happening everywhere in the country.
My lord, this matter was challenged before your lordships. This High Court struck down on the basis of a judgment delivered by the Patna High Court. Then the Patna High Court judgment was carried to the Supreme Court. Supreme Court sustained it. And then, my lord, while the government carried this matter up to the Supreme Court, this our matter. In the Supreme Court, a statement was made that we are redoing it and withdrew the writ appeal, and thereafter made the OPSC. There was a point in that writ application also that the OPSC concurrence has not been taken before the amendment. So they got the concurrence and repeated the same rules. Lord, to satisfy the test, Lord, one must be, is there a rationality behind the rules, Lord? And does it destroy the eligibility criteria prescribed in the Rule 6. Because Rule 7 is method of selection. Method of selection cannot prescribe some other different mode. You have to choose from amongst those qualified engineers. You cannot prescribe that the BTech is the qualification. You cannot say that the postgraduate marks will be taken into consideration for selection. The objective test was already there. So that is one thing.
No, but where is the Supreme Court's decision?
Mala?
Where is the Supreme Court's decision on this point? You said that a matter had
The
gone to-
Patna High Court matter was carried, I have given. Mala.
And what is gate?
Gate is a test, my lord, prescribed by institutions of management to test the eligibility for acquiring higher education.
The test, the name of the test is graduate
Aptitude test.
test
Test in
examination-
engineering.
Test in engineering.
Yes.
So, test in engineering.
The Patna High Court case I have also given, my lord. Patna
Yes.
High Court case was this, my lord. The qualification was prescribed for recruitment that you must have qualified in the gate. Patna High Court told that the eligibility criteria is something different and you are confining the selection only to the persons, those who have appeared in the gate examination. That is not permissible. And there is no objective correlation with the objects are to be achieved. Dear Lordship knows that there can be a classification, but it must be reasonable. So it must have an objective nexus with her. Then that matter was carried by the state of Bihar to the Supreme Court. Supreme Court confirmed the Patna High
Where is the
Court.
Supreme Court's decision?
Lord, that is there.
Court's judgment.
Because I am given to understand that the
And page 109, page 109,
page 109.
that is the continuation of judgment delivered by this court.
Yes, yes.
You were arguing that matter. You were arguing that matter.
Yes.
You were arguing
Yes.
that matter.
No, we want to know, according to you,
Yes, yes.
the Patna High Court
Yes, yes.
has taken a view that gate could not be
That is
It
no
doesn't need it.
substitution for qualification.
No, gate is not substitution for, it's not a substitute for qualification. Qualification remains the same
Yes.
because for gate examination also, that is the qualification.
That's right.
So those who will fulfill the criteria to appear at the gate examination, they also fulfill the eligibility criteria under the rules.
Right, right. Mullah.
Right. But according to you,
That is an
Patna High
exclusion.
Court, Patna High Court
Yes.
has had struck down and which has been
Yes,
affirmed by
I
Supreme
have
Court.
given
So if
Milord.
that is the situation, then nothing remains.
Milord, that 209 is the judgment of the Patna High Court, Milord. Page 209, Milord.
Page 117 of that earlier judgment, Patna High Court judgment is quoted
Yes, yes.
at paragraph 20.
I have given that Patna High Court judgment itself in page 209, Milord.
Page 209
Yes, Milord.
should be the
Annexure 11. Annexure 11, that is
Annexure 11.
222.
just.
Has your Lordship got it?
Annexure 11.
Annexure 11, Milord.
Yes.
Then the Supreme Court, Milord, your Lordship will find the last
Just a minute.
order. Two 36.
Now we are going through that Patna High Court judgment.
I am given to understand that two other writ applications on the same point, your Lordship has issued notice and is pending before your Lordship. But they say that when it is all right to give weightage by the government to a particular class of people, but to exclude others, it means exclusion of others who has not appeared in the gate exemption, and gate exemption is not a mandatory exemption.
Yes, what happened in Supreme Court?
Supreme Court, my lord, the SLP was dismissed.
SLP was dismissed.
That is page 236, my lord.
Entertained SLP.
And where is the decision of this court?
Decision of this court I have not given. It is probably reported decision, my lord. I have quoted.
That has been annexed.
Sorry, sorry.
Page 67.
Annexure?
Annexure 6, my lord.
Similar. Similar.
That matter.
In your opinion, it is similar.
Not similar, really. That
Like there was an additional point, my lord, that OPSC concurrence has not been taken.
yes.
That they rectified. The other Justice Alpat's finding, that has not been set aside or rectified. The page 160, your lordship may kindly see the earlier finding.
This was by a single
No, division. bench.
Division.
The page 160, your lordship, may I draw your lordship's kind attention to page 160, paragraph 13 of the earlier judgment. Paragraph 42, madam. It page 166. May I place it?
yes, he has a point.
Yes, so similar matters, your lordship have issued notice that is pending. And your lordship, this is the judgment. 2021 rule was declared ultra vires. Lordship has seen that rule at page 54.
I have not got the other judgments on Article 14 and other things because it is in the
Yes,
stage
madam.
of admission. If you want to argue, I am
No,
prepared to argue.
If other matters are fixed, your lordship has fixed for next week. I can
Lord,
furnish the
let it
number.
be tagged with this so that there is no
Matter can be decided.
multiplicity of hearing may not.
Mr. So accepts notice on behalf of the opposite parties. Who is for the commission? Commission is not a party, not required.
Commission is effective.
Commission, Mr. P.K. Mahanti,
P.K. Mahanti,
senior counsel
senior
is
advocate.
appearing.
They have a panel, madam.
Senior counsel, Mr. P.K. Mahanti normally appears.
Senior counsel is engaged, man. Senior
No, no,
counsel
no,
would not
no, I
take
am
notice.
saying normally he appears. I am saying normally he appears.
No, but commission is a party.
Yes,
Yes,
All right, we'll list this matter along with WPC so and so. Whether any date has been fixed.
well, I don't
For
know.
that,
I
date has
think
been
your
fixed.
lordship has
I cannot give that
stated
for
a
a date.
counter the Nazi.
No, please try that. A date is fixed because this is an important matter.
Yes, madam, that we are also wanting for disposal of this
Ah.
because in some cases,
We are,
Then-
there are different contingencies. I'll come to that scenario. I don't want to waste your lordship's time.
no,
No.
three matters are there. Earlier two matters are there challenging the virus. of-
Auri achi.
See, first of all, we will have to address the virus.
Yes, madam, that I,
So once
that,
that is over, then we can take
Yes.
up other matters.
yes, madam, that I am submitting. Two matters are there challenging the virus and another matter 2 days. And some other matters were before the honorable single judge, they have challenged that advertisement.
So
Unless
it is-
your lordship decide this, so if your lordship decides the virus, then all the matters will be covered by that.
Naturally.
That
If I lose, then everything goes.
because we
If
have,
I win, that advertisement in pursuance of this notification
Yes.
has to go.
that I am submitting because we have issued
so
the
please
advertisement.
tomorrow tell us
Madam.
as to on which date we can hear these matters.
Madam, I can say today after lunch, I can say it. I can submit it. Madam,
Tomorrow you tell
Yes,
us.
yes, madam.
All of you have consent from the other. You are appearing in all the
Any
cases.
that is convenient, it is virus. They didn't file a counter also.
In that case, first case counter has been filed.
Well, I don't know. Right.
Any date? Monday?
Well,
Monday.
for final argument.
Yes.
Yeah, subject to what the other council says, they will not.
Therefore, we are saying that tomorrow you just make a mention in the morning as to which date would be convenient for all of you.
69.
Then we shall decide.
I would be, se dita kiye file karchhe. Oh, Mr. Sub.
Then one has been filed by Mr. B. Rautra, senior counsel, and another by Sushant Das.
Subir Pandit is appearing.
And in that case, Mr. Subir Palit, senior counsel, is appearing.
I will ask them.
My lord, if you
I'll ask them.
permit me, I'll intimate that. Lord, fix any date so that I can intimate that.
No, we will not
Take,
fix
by
it
taking,
today.
yes, my
Like
taking.
Tomorrow you make a mention.
My lord, I'll make.
Council, you can
So
make a
far I
mention.
am concerned, any date that is convenient to court and convenient to you, I am ready.
And in the meanwhile, before the date is, before the matter is taken up, in the meanwhile, you may give your citations or whatever
Yes.
you are going to.
Yes,
say on.
yes.
All right. And the rules are at different places, like amendment is at place.
No, I have given all stage by stage, those rules I have annexed. All the rules I have annexed.
No, it will not be listed tomorrow. This case along with Recruitment. Sir.
That is,
And then-
you will find it by way of a memo which date is convenient to all. So far I am concerned, I give him.
My lord, I will talk with them and I will make a mention tomorrow.
I give him a blank check. If any date.
Necessary details, the
Why
case,
have you come here? There is appeal.
your lordship. Your lordship,
NJT, you have appeal against that order.
your lordship, it is already decided by numerous cases that the petitioner should first approach the High Court under 227 instead of directly approaching the Supreme Court, your
Where
lordship.
is that?
Your lordship, apology, your lordship, this item kindly be taken
There
over
is
after
no
lunch.
such decision.
Lordship, I will cite this.
There
for
is
your
no such decision
lordship.
that where appeal is provided before
lordship.
the Supreme Court
Your Lordship,
The person should go to the High Court first under Article 226.
Your Lordship. Your Lordship, under L. Chandra Kumar and everything where inherent powers of the High Court are saved by under
Very
Article
difficult to
226.
convince.
In NGT case,
Your Lordship.
it has already been set at rest by Honorable Apex Court. Recently, we have
Your Lordship, in that case, I
This
may
bench has
kindly
not-
submit that, may kindly be taken up any other day, I'll satisfy Your Lordship.
Why unnecessarily have you filed this petition?
Lordship, on basis of L. Chandra, I'll go through all the decision, Your Lordship, I'll satisfy Your Lordship.
No,
Any other day, Your Lordship.
sorry. The consumer forum. Vikas Kumar is not consumer forum. In the present writ petition filed under Article 226 of the Constitution of India, the petitioner has put to challenge an order dated 29/12/2023 passed by the National Consumer Dispute Redressal Commission, New Delhi, in first appeal number 86 of 2020. You have, there is this. Our High Court order passed in.
Your Lordship.
Where is the order passed by the?
Your Lordship, at annexure 18, Your Lordship, page 165.
Before the National Commission, you have filed under section 19, read with 21.
Your Lordship. Lordship, over here only section 19 is mentioned. I'll take instruction and properly apply your Lordship. Lordship. I'll peruse and properly apply your Lordship. Since I don't have the petition copy, your Lordship.
Item number 11.
May I pray, my lord, by means of this application, the petitioner seeks to challenge the rule that has been introduced in the with effect on 30th December 2022 by making an amendment rule 90A inserted to Odisha Development Authority Planning and Building Standard Rule. You'll also find out at page 119, Annexure 7. A, my lord. May I please? Page 119.
Yeah.
90A.
Yeah.
My lord, there at the bottom your lordship find the Odisha Development Authority 2 on short title and extent of commencement. This rule may be called as Odisha Development Authority Planning and Building Standard Amendment Rule 2022, and they shall come into effect on the date on their publication in the official gazette. The Odisha Development Authority Planning and Building Standard Rule 2020, after Rule 90, the following rules shall be inserted, namely 90A, regulation of unauthorized subplot, where in a plot, may I place my lord, where in a plot has been subdivided into subplot unauthorizedly before the date of commencement of the Odisha Development Authority Planning and Building Standard Amendment Rule 2022, an application for regulation of such subplot, if filed, shall be considered by way of compounding subject to the following condition. Now, lordship may leave that first condition, that's I'm not questioning. The third condition, my lord, second condition. The applicant shall deposit compound fee equivalent to 15% of the benchmark value of the subplot and all applicable fee prescribed for subdivision of layout. Now, my lord, firstly, this imposition is ad valorem based on the market value, and 15% has been charged. So this is primarily in the nature of a tax and try to be introduced through rule. My lord, so my submission is it violates Article 265
So you want this
to be declared invalid.
data?
Yes, madam. Yes, madam.
Do you know what submission of it?
My lord, I'm saying that
We declare 90A otherwise.
but to the extent of compounding fee.
Not the tax. Did you have the town planning or whatever the development plan?
Madam.
And therefore, a concession is being given. You are being asked to pay this much of amount, maybe for the purpose of development, not in the nature of tax.
My lord, this fee which they are collecting is for general importance. And now the Honorable Apex Court has settled it in this way, that once it is collected for revenue purpose.
This is not for revenue.
Yes, my lord, they in Rule 91, they themselves say that whatever fee will now collected, which is to be utilized for a general purpose activity. So this nature is not a quid pro quo vis-a-vis the petitioner. That's number one. Number two, my lord.
Suppose you violate
But-
the building plan sanction.
Absolutely, what your lordship saying is correct. Here I have did nothing. Here I have purchased a piece of land and applied them for a building plan. For granting that, they are saying that the original revenue plots out of which I have purchased my land is violated, you have violated that. That is the fraction. So for that,
Was given a plot.
no, my lord, I am from a rightful owner or recorded tenant, I purchased by means of a lordship may come to my sale deed, that will be better. Kindly come to your lordship, page 47.
What is the definition of plot?
My lord, plot has not been defined. It's defined as final plot has been defined. That's right, Leo. So that's the second ground of my challenge.
Defined?
No, it's defined as final plot has been defined. And reconstituted plot has been defined. There is no development. I have also taken the ground that it is vis-a-vis Odisha Development Authority Act, this rule is violated. And thirdly, the rule-making power which has been used doesn't empower them. Plot has not been defined. And your lordship kindly turn to Odisha Development Authority Act. May I just keep 2 copies?
19 capital A,
Yes.
plot has been subdivided into plot unauthorized.
Yes, madam.
There must be.
The plot has to be defined and there has to be no.
You cannot subdivide into subplot.
Well, restriction with respect to final plots. That's what I'm drawing your lordship's attention to. Rule 2XI. XB. Sorry, section 2XB of Odisha Development Authority Act. (215), my lord. Final plot means a plot reconstituted from an original plot and allotted in town planning scheme or development scheme or approved layout of land as final plot. So original plot is something else and final plot is something else. Now I admittedly purchased fraction of original plot and there is no declared final plot. How the final plot will be declared? That's my lord, development plan from section 8 to 13. And reconstituted plot is under section 28. It's also a definition under section 28. These 2 things has never happened for the city of Kottayam. So there is no declaration of final plot with a layout which I am violating, for which they are imposing. So that's another ground of my challenge in the writ application, that under the scheme of the act, there being a lot of things has not taken place. Lordship can return to chapter 4. Sorry, chapter 3, my lord. And everywhere it is used development plan. So it commences with interim.
Plotting has not been done.
Not done. And to demonstrate that, I have placed on record one document that your lordship can find out. Unfortunately, I should have put it the color.
Town planning scheme.
Town planning scheme has not been notified. And I may think I've given the copy to the CMC and as well as the VDA.
This amendment, if your lordship will see, he has purchased a subplot from his vendor.
Yes.
The full plot is there. He has purchased a portion of it. And according to this amendment, where any plot has been.
He purchased a piece of land from a plot.
From a full plot.
From a full plot. Was there any restriction?
No, this is a subplot and this restriction has been made for the subplots. Where this subplot has, yes, there is restriction.
When he purchased, when did you purchase?
I purchased in 2021, one day.
When he purchased in 2021,
Yes,
was there any restrictions?
that reveals from the amendment itself that it is unauthorizedly made subplot. That is why he is being charged
2020.
22.
So how do you say that that was unauthorized? There must be some declaration that this act shall be unauthorized.
Retrospectively to be made applicable because
No, you cannot. Because you look to that rule. They shall come into force on the date of the publication in Odisha Gazette.
Sir, even
Yes.
otherwise,
even if this amendment is made applicable, it cannot be retrospective.
no act can be said to be unauthorized from date of declaration, prior to the date of declaration. Suppose some act is done today, and tomorrow you say that if something has been unauthorized that we from a previous day,
Yes.
then that is impossible because on that day it was not unauthorized.
On the date of sale date.
On the date of sale, that was, how do you define unauthorized? Unauthorized, subclause unauthorized. There must be some restriction. And if there is no restriction, then find the difference.
So far as the individual petitioner is concerned, I think CMC has
It's not individual. We must understand that because it will have very wide ramification.
We'll give a reply to it.
Sale deed is of 2018.
Yes, sale date is 2018 and
18 and
amendment is of
21.
2020.
Oh.
That I have.
And you have made prospective.
Yes, prospect.
Sub rule 2 of
If the
Rule 1 of-
sale deed was of 29 December 2020. Question is that when you say that this was unauthorized, then you will have to show that on that day there was restriction which was violated.
Yes,
As simple as that.
yes, I got it.
And for the CMC.
I'm for the CDM. I'm for the CDM. We are from
opposite party number 3.
And it may have very serious repercussions. If we interfere, we decline to interfere in both the cases.
In fact, such challenge has been made in the perimeter provision in Uttar Pradesh. And Allahabad High Court declared it ultra virus, this subdivision. Then it went to the Honorable Apex Court. Apex Court upheld that. And I'm relied upon in my petition also. I'm relied upon that.
Mr. Naik, you are appearing for
The
2
municipal-
and 4.
CMC, 2 and 4.
And today they are asking me 90 lakh rupees for that, to grant me, to allow me building permission. The building permission plan has been granted. I have deposited the other fees entirely as per that. But this fee is around 90 lakhs.
How much time?
Well, it's 4 weeks. 4 weeks.
But may I pray that this fee may be stayed for a while. If I lose, I'll pay them with interest. Otherwise, my lord, Lordship can give me a predicament. I'm already committed to he was took for construction of a hospital.
Just see how.
No, my lord, I cannot today run away because the constructions.
These rights should have been stay in the statutory. And if we allow your submission, if we accept your submission, then that will amount to stay in the operation of it. You don't.
No, my lord, I just beg before a lordship this way. I undertake it to,
Maybe undertake.
but I'm not asking for staying of that. I just a deferment I'm praying.
Yes. It is binding on everyone.
No, my lord, they have a provision to they take it at the time of granting of, that is a provision, my lord. No, my lord, what I'm saying is that there is a provision to collect it at the time of granting occupancy certificate.
Regulation.
Rule 19.
We reject the submission as that will amount to the staying operation of statutory rule, which should not be done by a court.
Item number 12. Published.
May I please, my lords. Here, my lords, annexure 11, 12, 13, and 14, my lords. That's all the notifications are under 168 day of the OGST and CGST Act. Your lordship have kept all the matters to 2nd of May, my lords. And here, my lords, order copy I am giving, your lordship will delete paragraph 4. Paragraph 4, your lordship asked me to implement Union of India. But here I have already implemented Union of India. So paragraph 4 may not be there. We will delete it, all other be there. So cause notice, your lordship have permitted to file reply, but that will be without leave of the court, 2nd of May only, my lords. Same order, paragraph 4 be deleted.
I am for 2, 3, and 4. You have already instructed to appear for GST council.
Yeah, for GST council.
Yes. This commissioner has been given power to file affidavit on behalf of the GST council.
Item 13.
Published.
No complaints.
Except for 13, no cases, there are 7 to 8 cases. Here I have already obtained instruction, excepting one case, SLP has already been dismissed in respect to others. Now, the concerned officers have been asked to give the details of the financial implications so that amount can be paid. Because of this, some more time will also be granted so that we can do it.
6 months are there, it is taking
Yes,
time,
I don't know.
time to time it is taking.
All right. 2 weeks is taking. 2 weeks.
3 weeks also because
3 weeks, all right. List these matters on 3 weeks. That 2 weeks after, no, before vacation.
yes, before vacation.
Huh?
21st May.
On 20th May. 20th May. So,
Third week.
so 20th.
It will be 3rd week.
Yes,
3rd week, 20th.
yes.
20th May. So as to enable an AGA to seek instruction as regards compliance of this court's orders, violation of which has been released in the recent batch of contempt applications.
Item number 14.
14
Also same,
14
batch, different.
14 same order.
Item 15.
My lord.
Order 10 for 2023 has not complied, my lord.
This lordship take it at 2 o'clock. One matter also has been kind enough to take 2 o'clock. Yes, it's cut off only. I will obtain instruction.
2. Item 16.
16 order has been complied with. But lordship, there was a direction. Lordship, kindly look at the order passed by this honorable court. My friend has quoted the order, but he has not filed it. If also sees page 3, my lords, paragraph 5.
Which
the
item is this?
Order of this honorable court, my lords.
What was the order?
Page 3, my friend has quoted the order. Page 3, paragraph 5. In view of the above, this writ petition stands disposed of, directing opposite party number 1 to issue necessary clarification to the land acquisition zone officer Rajashpur for the Vigilance Jajpur pursuant to letter dated 19 to 22 under Annexure 9 and the remainder dated 7/7/22 and of the 10 and 11 expeditiously. Now the clarification has been given by the opinion number 1, that is the contender, that if he wants to acquire it, it has to be acquired under the new act, not under the old act.
Just now I have the served copy. Let it.
No, but the order has been implemented. Order, there is no violation. So you shall be at liberty. Then AGA representing the contender. Contenders has brought on as produced before us later dated 26/4/2024 of what is OAS? Officer.
Yes, he is the, as per the direction of the opinion of the contender, this order has been passed by the, communicated by the officer in concern.
OAS. Oh. By special secretary to the government, addressed to the collector and district magistrate Jajpur. As directed by the contender.
Yes, no.
Who is the contender?
Secretary, he is
Revenue and disaster management.
Bracketed secretary and revenue
and
And
disaster
disaster
management.
management.
disaster management relating to clarification on passing of award and payment of compensation in respect of additional acquisition of land, which was subject matter of WPC number 12818 of 2023, which has been disposed of by an order dated 4/5/2023. So this contempt application relates to disobedience of the said order of this court dated 4/5/2023. Up next, after having perused this in communication, we are of the view that no case of deliberate disobedience of this court's order is made out. The contempt proceeding stands stopped.
Item 17.
Please. Lordship directed the state government to obtain instructions, my learned senior to obtain instructions for non-compliance of the order dated.
Yes.
No, sir. I've received instruction that if you also see the order of this honorable court minutes, paragraph 3, page 10 minutes. Prayer in the petition is for a direction upon the opposite party number 4 to supply composite list of 1175 workmen submitted by the union on 1st of November 2019 minutes. Now the workmen, they prayed minutes for a direction to the officer to supply the letter which they had submitted earlier minutes. In fact, I've obtained instruction that not 1175 list was not submitted, ever submitted by them. Rather, on the basis of a list submitted of 1132 persons, my lords, a dispute has already been raised before the PO Labor Court, my lords. And if there is any dispute so far as balance, my lords, 34 is concerned, they can all approve directly to that Labor Court, my lords, because of the new amendment. There no reference is required, my lords, they can directly approach to the PO Labor Court where, my lords, dispute is going on, my lords.
So what do you want?
You know, the union has supplied 1175 numbers of workers, my lord. And the reference was made for 1135 numbers of workers. Now, during pendency of the sheet application, they have filed a counter. No, that is not 1135, that is 1132, my lord. That is why I have filed a writ application with a direction, the Additional Labour Commission to supply the list of 1175 numbers of workers as per my representation. Now they are saying that no, not 1175, not 1135, 1132 number of workers are there. So that means so many workmen were left out, my lord. So I am one of them, my lord. My name does not found place in the 1132 also. So that is why I pray for a supply of a list of that workmen, which has been supplied by the union during the conciliation proceeding. They dispute that no, that is 11, never the 1175 number of workers has been supplied, only 1132. But reference for the state government letter shows the reference was made for 1135, not 1132 also. Now they are saying 1132 numbers are there. So let them supply the 1132 numbers. I will file a so far left out workers are concerned, I will file additional list before the Labor Court.
That I can do, my lords. 1132 numbers in respect of whom reference has already made to the London Labor Court. That list I can give to my friend so that for valence he can raise the dispute, no problem, lord. But there is no.
But why didn't you supply it?
Huh?
Why didn't you supply? That was the direction.
No, 1175, that is not with us, lords. We say.
1172, 1132, you have to supply.
Yes, that has been given. That in the counter affidavit to the main petition, lords. The writ was pending, lords. It was a part of the writ petition, lords, where a counter was filed by the state on 28/11/2023. There 132 number list was given, lords.
I fail to understand the circumstance in which such writ applications are filed.
Now, after filing this writ application, they have amended 1135 to 1132.
What he said, that along with counter affidavit.
1132 numbers they have supplied.
They have supplied
1132 they have supplied.
1132 or 1135?
1132 only. They have amended 1135. Yes.
Yes.
They have supplied 1132. But my grievance is the union supplies 1175 numbers.
So you request the union can give you that these were 1175 persons.
Union has already supplied during the conciliation proceeding. But the Assistant Labour Commission supplied that union has never supplied.
So you can.
So union can only answer. How can a writ be made?
Read, my lord, so far the read is concerned, there is an order passed by the Labour Commissioner that since the Labour Commissioner comes under the statute, he can direct state government to supply a list. That is why the writ application was filed. It can direct neither the Labour Commissioner nor the union to direct to supply the list. The we approach the Labour Commission to, with a request to to direct the state government to supply the list of workmen. But he says that since I was appointed under the statute, I can't direct.
As per Mr. Samanta's
Yes,
statement, you can, if you are left out, you can very well raise dispute.
Yes. With
you
that
were left
observation,
out,
also may dispose.
and your union will come to your rescue.
Yes.
There.
Yes.
Why did you file this writ petition?
No,
Read question because they have.
No, why did you file?
Read question well, because of composite list has not been supplied. That is why you have filed. The read petition was filed. Even if our representation, the order the order of the learned tribunal, the tribunal being a creature of the statute lacks competency over the order of the government which has referred a particular dispute for adjudication. In that view of the matter, when the government has specifically referred the dispute confining adjudicating relating to 1134 workers, the prayers were made by the second party to ask government to furnish the list of 1175 workers as per the conciliation is not tenable. However, as the list furnished by the government indicates name of 1132 workers, instead of 1135 mentioned in the order of reference, a letter of request be sent to the government either to furnish the name of the 3 left out workmen or to issue.
See, the 1175 names were supplied by the
union.
It is the union's case that 1175 names were. The union could have raised this grievance.
Even if 1175 names were not supplied, my lord, but the Assistant Labour Commission after the failure report does not enclose the 1175. He has only enclosed 1135. Now the state says reference was made for 1135. Now they have amended it to 1132 also.
Right.
That is why we ask for the court below.
Who are 43 persons?
Yes.
Who
are those 3 persons?
Who are those 3 persons?
These including me, another 2 persons are there, my lord.
So you are one.
Yes.
So you can have
we are 2, my lord. We are 2. The petitioners are 2 persons, my lord.
2,
my lord.
But what is this 1175?
1175 others are.
You comply with the order. Whatever order has been passed, you implement it.
We'll give them the reply because there is a direction to give the reply. Within 7 days, I can comply the order.
This is case on 1 week for the estate to inform compliance of this court's order.
Item 18. Item 18, my lord, there is 104 days delay after excluding that COVID period. My lord, learned friend has appeared. If your lordship will condone that delay.
I filed the objection to the condonation of delay petition. I have stated that since they have completely participated in the proceeding and in the court below and filed their counter and all these things, so COVID period is not applicable to him and they are not properly explained.
The period is applicable not because of him, because of the Supreme Court.
The Supreme Court, they have
So
taken
that will have to be excluded.
They have only, as your lordship pleases. And he is a retired person, so for hearing, we have also filed
that matter can be heard next week any day.
Next week or after vacation, as your lordship pleases.
After vacation.
As your lordships.
Delay of 104 days.
Filing. Sir has pointed out more days delay. That 268 days because that period has not been excluded. That COVID. So,
though the office has pointed out delay of 258 days in preferring the present appeal, it has been rightly pointed out that there is delay of 104 days, taking into account the Supreme Court's, have you seen Supreme Court's orders passed in so and so. Full stop. After having heard learned counsel appearing on behalf of the appellant and learned counsel representing the respondent, and also having seen the explanation put forth in the application seeking condonation of delay, we consider it, we deem it proper in the interest of justice to condone this at delay. Stop. Delay accordingly stands condoned. IA number so and so is allowed. IA 2943. List this appeal for admission as a fresh case. It will come as fresh case. Well,
Item 19.
May I please, your lordship. Well, in this case, pursuant to the order passed by this annual court on 7/12/2023, I filed this interim application for condonation of a delay. My lord, in this case, my lord, the office has pointed out 213 days of delay in filing the review petition. But my respectful submission, my lord,
what is the review application? Number 283.
Review petition number, my lord, 283 of 2022. This review petition has been filed, my lord, pursuant to the direction of the Honorable Apex Court in SLP number 12669 of 2022.
No, but this application was earlier withdrawn.
Well,
the review petition was.
No, that was not a review petition, not. That was the interim application, was withdrawn with liberty to file better application.
All right.
Because no period of delay had been mentioned in that petition. Well, in this case, my lord, the Honorable Apex Court, by order dated 12/8/2022, permitted the petitioner to move in review.
Well,
to approach this annual court by filing review petition seeking enhancement of a compensation. Only, my lord, the amount of compensation, enhancement of
which order of the Supreme Court? 12/8?
12/8/2022.
Yes.
Therefore, my lord, my respectful submission, my lord, the period of delay which is caused prior to the order passed by the Honorable Apex Court granting liberty to the petition to approach this annual court, that period of delay may be condoned, my lord, in view of section 14 of the Limitation Act. And if that period is excluded in computing the period of limitation, then there is a delay of, my lord, 45 days of delay. My lord,
No, that cannot be, that period cannot be excluded. That period can be taken into account for the purpose of
because my
condonation or delay.
My lord, petition was bona fide litigating before the Apex Court.
Yes. So therefore,
it is a 4%. Petitioner, my lord, only is seeking enhancement of compensation of rupees from 50,000 to 1 lakh, my lord. And after rendering 13 years of service, my lord, he was disengaged by the management. And it was also the finding of the specific finding of the London Labour Court that the disengagement was illegal. But instead of directing reinstatement of the petitioner, only awarded 25,000 towards compensation, which was enhanced to 50,000 in the writ petition.
which for the other side?
Well, notice because it is for.
Who was appearing earlier? What is the order under review?
My lord, order and review is, my lord, under Annex 1, page 8, my lord. Your lordship kindly see my review petition, Annex 1, page 8. relevant person is the order of, is at page 9, my lord. Paragraph.
Yes, we are condoning the delay
Obliged.
and dismissing your writ petition, this review petition.
My lord,
Dismissing your review petition.
my lord, petition is a poor person, but
Yes, poor person, therefore that was enhanced.
my lord, enhanced, my lord,
What is we have our own limitations.
my lord, in similar cases,
Entertaining review applications, sorry.
in similar cases, my lord, the Honorable Appeals Court also awarded compensation to the range of.
Appeals Court can do that. But the limitation, there is a limitation while entertaining a review application. The petitioner seeks review of review of an order dated 13/4/2022 passed by a coordinate bench of this court in WPC number 2791 of 2011. Against the said order dated 13/4/2022, the petitioner had approached the Supreme Court by filing special leave petition, which came to be disposed of by an order dated 12/8/2022 with the following observations. वो कर दो, quote कर दो order. Order quote कर दो, speech initial. Oh, stop. It can be seen from the coordinate bench order dated 13/4/2022 that the Labor Court had awarded compensation to the tune of rupees 25,000 in lieu of the petitioner's reinstatement. So stop. It was the petitioner's grievance that the amount of compensation was not adequate. Stop. Striking a balance between the condition of the petitioner and that of the management also, the coordinate bench decided to modify the amount of compensation, to revise the amount of compensation by enhancing it to 50,000 in place of 20,000, 25,000. Stop. Next, there is delay in filing the present review delay in filing of the present review application. Learned counsel appearing on behalf of the petitioner has drawn our attention to section 14 of the Limitation Act and has submitted that the time spent by the petitioner before the Supreme Court may be excluded while considering the period of delay. So stop. In the facts and circumstances, the petitioners have facts. आइए नंबर जहाँ पे लिखा है ना आइए नंबर नीचे लगते हैं. Circumstances, this application IA number so and so is allowed. The delay stands condoned. Next, adverting to the merits of the case, we do not find any additional material brought on record for this court to reconsider enhancing the amount of compensation. So stop. Further, from the order under review, it appears that the coordinate bench had taken into account the submission made on behalf of the management, that the management's financial condition was not very good. So stop. Next, keeping in mind the limited scope of a review of an order, we are not we do not find any merit in the present application, which stands dismissed.
Item 20. This matter may be taken up tomorrow. Mr. Misra will do this matter.
My lord, item 20, respondent number 525 and 470, 90 already allowed in regular.
They have been allowed in compliance to my lord's order. They have been allowed. There is no problem. Mr. Misra will do it if your lord's
tomorrow.
Any other date, my lord, hearing. Any other date.
Tomorrow it will come under the same. This has come for orders.
It will come for tomorrow for orders. Tomorrow. All right. Item 21.
May please, lords. In this case, there is a delay of 44 days, my lord, in filing the appeal. And as per your lordship's direction, I had served a copy upon my learned senior.
I am appearing on behalf of the respondent.
The
staff selection.
Do you oppose? Are you opposing?
Yes, but with respect to that limitation, I do not.
Allow limitation 44 days. Is there any private respondent?
No, my lord. He state I am appearing for 2, 3, 4. He is appearing for 1.
Something like that. Yes.
Item 22.
Minors. That matter, minors, called university VP for minors. There is a delay of 210 days, minors. Directly me to file that additional affidavit, and I filed that additional affidavit. I also filed a date chart, my lords. My humble content is twofold. The university, what I found, my lords, on circulation different stages, my lords, the university tried its level best to get a decision. And after the decision taken, my lords, they prefer the appeal. And my humble contention that limitation is 220 days limitation is there. Suppose my lords, I'm unable to appraise my lords, convince my lords that yes, this period may not be my lords condoned. Then also my lords, I pray, humbly pray, referring to the decision of Honorable Supreme Court, if it involves a point to be decided, my lords, and there also Honorable Court should be lenient enough to consider that limitation part, my lords. Here in this case, the whole total point is, after Umadevi case, can there be a direction to those who have joined my lords thereafter, can there be a direction to my lords frame a scheme for regularization? That is the point. 220 days delay, I have given the date chart, my lords. The file movement, the total movement of file, whatever available, because I was not there, my lords, during that period. Subsequently, I joined as a registrar. Whatever I got from the record, my lords, I have given the detailed date chart, my lords. Only 210 days delay, my lords. This case was filed also way back in the 5/9/2023, my lords. Appeal was filed on 5/9/2023, my lords.
So we will have to consider this court's decision. That is.
Referring to this decision, my lords.
But you will have to satisfy us in view of the law laid down by this court in case of Surma Manjari. How do we distinguish?
Surma Manjari.
Many cases of writ appeal filed by state sitting along with Justice Sarangi. I was party to that.
Yes, ma'am.
And inordinate delay beyond 90 days, normally we did not.
That is exactly, ma'am, I'm referring to a decision of.
Even taking into account 20-25 days back.
I also, ma'am, referring to that decision, ma'am.
Supreme Court has said, you cannot go into the merit to assess the
Master,
merit.
here, my lords, I am referring to another decision of Honorable Supreme Court, my lords. Of course, it arose from our Honorable High Court. My lords, there, my lords, the case was, I was, of course, my lords, with due humility, I was a party there. I also preferred appeal on behalf of Bhubaneswar Development Authority. There was a delay of 564 days. Paragraph 12 minutes. Paragraph 12 read with paragraph 14.
Yes.
Paragraph, there was a delay of 564 days. Also, paragraph 14. Also, we have perused the reasons which were placed on record of division bench for condonation of delay. The state had explained the detail of the steps which were taken to take necessary approval of for the purpose of processing of the writ appeal. Besides declining to condone the delay, in this case would have serious consequences of allowing an important imposter to continue having the benefit of a reserved seat. Well, that was the law point involved.
This is a serious issue.
Yes.
This is a serious issue with regard to caste certificate.
No, not serious issue, matters that is relating to the caste, not caste, but maybe a serious issue that it involves a point of law. That is what Honorable Court say.
All right, we will consider. Do you have that Manjari's decision?
Yes. That is the decision, matters. This is arising out of our Honorable High Court.
We want to take up.
Yes.
We will take up this matter.
Matters. Fix up any date, matters.
Who is appearing for the other side?
My lord, I am appearing. I am appearing for the respondent, my lord.
Yes.
we have filed our objection
Yes.
because there is a delay of 220 days. So therefore, your lordship, I may submit my lord on delay because by order dated 5/3/24, your lordship has pointed out that first your lordship would consider the condonation of delay part only.
Mr.
So therefore, your lordship may
Mr.
fix a
Patnaik.
date. Yes, my lord.
Mr. Patnaik, today, Mr. Mahapatra has cited one judgment, 2023 SCC Online, Supreme Court, 977.
All right.
Ms. Patnaik, may can
Yes, my lord. Yes, my lord.
Bhubaneswar Development Authority versus Madhumita Das.
All right, my lord.
So that is
Your lordship may fix a
2023 SCC Online, Supreme Court 977. Their 564 days delay has been condoned, looking to the preliminary assessment of the merit of the
merit, my lord.
matter.
So your lordship may also appreciate the merit, my lord, preliminary aspect, my lord, because this is a case of regularization. The lordship may fix a date, my lord.
No, we will first decide the question of limitation. We will go into that
Yes,
also
yes.
for that
Yes,
purpose.
Yes, my lord.
All right. We will see. When do you want?
As your lordship.
When do you want? 1 week?
Yes, my lord.
Yes, my lord.
This matter. When senior counsel appearing on behalf of the respondent, sole respondent.
Yes,
Sole
my lord.
respondent has relied on a coordinate bench decision of this court. IA number so and so. This application has been filed for condonation of delay of 220 days in filing the present appeal. Stop. Opposing the said prayer, said application for condonation of delay, Mr. Patnaik and senior counsel appearing on behalf of the
Respondent number 1, my lord. I am for
respondent number 1.
My lord.
Respondent number 2.
I am for respondent number 2.
Respondent number 1 has relied on a coordinate bench decision of this court in case of Suman Manjari. So he submits that there is the explanation put forth by the appellant for condonation of delay is not satisfactory, and therefore the writ appeal should be dismissed on the ground of delay itself. So, learned counsel representing the appellant has drawn our attention to a recent Supreme Court's decision in case of Bhubaneswar Development Authority versus Madhumita Das and others, reported in 2023 SCC Online SC 977, and relying on paragraphs 13 and
12 and 14 minutes.
paragraphs 13,
12, 1 to 12, 12 and 14.
paragraphs 12 and 13,
14 minutes, 1 4.
12 and 14, he has submitted that this application for condonation of delay deserves to be allowed, as otherwise it would cause serious consequences. So, list this case on next week. Poland for senior counsel representing the respondent number 1 to respond to the submissions advanced on behalf of the appellant.
Grateful.
Because here I have received information, as I was telling me, this relates to National Highway Authority of India, not the state authority. So since 2022, the rate applications are disposed of, he has written to the National Highway Authority of India to comply your lordship's order. These are the orders, So if, then no.
All right, it will come tomorrow. It will come tomorrow.
Yes, ma'am.
And next one.
Item
Item 15.
In fact, now the nomination is going on, so there is a lot of crowd. So the
tomorrow,
day after tomorrow.
Day after tomorrow. Some matter was being mentioned in the morning. Item 60. You are in which matter? 60?
No, I am in item 10. Oh, sorry, I am in item 10.
Item 10. Item 10.
That it is taken up at 2 o'clock. That matter, that 3060, you also asked.
Ma'am.
Oh, Mr.
Item 60, it is the longest matter because the facts are right.
In fact, since we were told that you have come from Delhi
Yes, madam.
and you are staying in a hotel,
I am prepared, madam.
therefore we thought that you should not be put to any inconvenience.
I am prepared.
So what should, it's the longest matter then?
Longest matter.
A matter has been fixed at 2 p.m.
Yes.
So we are duty bound to hear them.
And you lots of
So when do you want? We can adjourn your matter to some other day.
After vacation,
All right.
18th or 19th. It may be in the top of the list.
We will see. We will fix a date.
All right.
Item number 10.
This is that matter that 30 seats, there was no dispute right from 2011-12. Every year they are given. That super 30 seat was enhanced to 60 in the year 2021. Super 30, there was no dispute. Your Lordship therefore asked the State Council, super 30 seats are concerned. What is the problem? So that they can give provisional admission from this year. Because right from 2011, 12, 12, 13, they are giving 30. They enhanced it to 2021. And subsequently, they have now said stop their admission. That is how you
As I understand, my lord, yesterday my lord asked me, as I understand, for 30 students, actually there should not have been any problem. But with the Apex committee comprising the principal secretary, that inquiry report which has already been shown to my lords, that it has decided and it has taken a decision to keep in abeyance. So up to 23, 24 students, my lord, I am informed the students will have no problem. But 24, 25 admission, which naturally my senior is pressing, I have the instruction, my lord, if my lord will take up this matter on Monday, we will only give the reasons why you have kept in abeyance, not even for 30 students. And if on that day, my lords will be pleased, my lords will even, if my lords will be pleased to grant interim protection, my lord, we assure this honorable court that we will not take any plea of portal being closed. As such, my lord, it is open till June.
If my Lord Prince wants that on Monday, it will come and.
At least I will give in shape of an affidavit for my lord's application.
So I don't think that for 30 seats
we should not have as it appears, but since the committee, I could not get a appropriate instruction from the government. So
30 students are concerned, I don't think.
Exactly.
30 seats.
No.
30 seats.
30 seats is not been.
I will humbly pray, my lord, to pass that order on Monday.
Can it not be Friday? All right, also keep it to, because my lord assures that there will be no problem for us.
Bless.
Item number 59.
In this case, my lord. Lord, in this case, my lord, Mr. Mahapatra is held up in another court, my lord.
Sorry, and henceforth we will not adjourn any matter.
My lord, my lord.
At 2 p.m.
My lord,
No circumstance.
By now you have been appearing in many cases. Why are you not getting prepared and come? You are prepared.
No, my lord.
Why are you not getting prepared? By now you have got good experience in this part.
Yes.
Lord, may it please your lordship.
What is the issue involved, Mr.?
So the simple issue involved is the MSME matter, where actually the award has been passed by the facilitating council.
Passed by?
The facilitating council, my lord. Under the MSME Enterprise Development Act 2006, under section 18(3). But that award was subject to be challenged under section 19 of the Act, which is similar to section 34 of the Arbitration Act. But section 19 provides if somebody wants to challenge the award, then he has to deposit 75% of the awarded amount, which is mandatory. That has been held by the Supreme Court and many other decisions, madam. They have challenged this before the Honorable High Court in writ jurisdiction, madam. The Honorable Single Judge held that though the conciliation proceeding failed, immediately thereafter the award has been passed. So therefore the arbitration proceeding as it was required to be undertaken has not been done as per law, and therefore it was observed it is not fair to direct the party to file an appeal and set aside the order and remit it back to the facilitating council. That is the subject matter of challenge.
Let us see the order first.
Yes, my lord.
Where is the order?
So order is, this begins at page 18.
Mr. One.
Yes, my lord. May I read it, my lord? My lord, if you kindly see, The first paragraph says the question involved herein once a proceeding is initiated on a complaint under Section 18 of the Micro, Small and Medium Enterprise Development Act, where the first go the council following the provision of Section 18 should undertake recourse of conciliation. In case of failure of conciliation for the provision of subsection 3 of Section 18, the proceeding is to land in dispute, and in such a case, if the council is justified in deciding the dispute without taking recourse to provision of the Act 1996. Advancing a submission while not raising the dispute that there involves a Section 18 proceeding, Mr. Mahapatra and a counsel of the petitioner, taking this court to the observation of the council at page 121, contended that the council, while passing the award, did not comply the provision of subsection 3 of Section 18 of the Act, and there is no taking recourse to the provision of said Act. Referring to the discussion in 2 paragraphs, referred to the award portion, a contention is raised that conciliation proceeding was lastly undertaken on 30/12/2020, and undisputedly the conciliation failed. Looking at the provision of subsection 3 of Section 18 of the Act, Mr. Mahapatra and counsel for the petitioner contended that in the above situation, it becomes bounden duty of the council to convert the proceeding to a dispute and to decide the same in terms of provision of the Act 1996. For the council not following the procedure at subsection 3 of Section 18, Mr. Mahapatra and counsel for the petitioner contended that there is no scope for award, and even if an award is passed, such award is non-existent in the eye of law. Mr. Mahapatra and counsel for the petitioner, taking this court to the condition in the agreement between the parties for having an arbitration clause, and they said once there is arbitration clause provided in the contract between the parties, there is no question of taking up the matter through counsel under Section 2006. It is on this stage of the matter, Mahapatra and counsel of the petitioner also brought to the notice of the court through the pleadings that in the meantime, petitioner, before even commencement of the conciliation, have already undertaken the exercise of the provision of 1996 Act. It is thus contended that once the proceeding of arbitration in terms of the contract is invoked, nothing prevented the contesting opposite parties, particularly the opposite party number 1, to attend the arbitration proceeding, get a dispute resolved through arbitration. Mr. Mahapatra and counsel of the petitioner also supports his contentious case, relied on the Madras High Court decision, reading through paragraph 39 and 40, attempted to submit that the impugned order is otherwise against the law and claims that matter be remitted back to the council for its fresh exercise strictly in terms of provision of Section 18(3) of the Act. Mr. Mahapatra and the counsel of the petitioner also brings to the notice of the court decided in arbitration 39 of 17, decided on 9/3/2018 to support his case. In opposition, Mr. JT, the counsel opposite party, while strongly opposing the move of petitioner for availing the provision of Section 19 of the Act, also contended that arbitration proceeding did not involve the claim of the petitioner. It is further contended by Mr. JT and the counsel that opposite party number 1, that even though the opposite party number 1 has already attended the arbitration proceeding, there is no possibility of resolution of the dispute between the raised by the petitioner. Mr. JT and the counsel for the opposite party therefore strongly objected to the claim of the petitioner on the maintainability of the proceeding. For there is an already existing arbitration proceeding involved remain not maintainable. Mr. JT for the opposite party number 1 was not disputing that upon failure of conciliation in an attempt of the council to exercise the power under Section 18(2) of the Act, the proceeding has been converted to a dispute. At the same time, did not dispute the submission of Mr. Mahapatra to the council that after initiation of such dispute, the council under subsection 3 of the Act, there has been no phrase calling of counter and following up provision of Act 1996. Mr. JT and the counsel of the opposite party number 1, however, taking the court to the provision of Section 19 of the Act, contended that even though there is provision for appeal, but petitioner did not prefer the same. On the other hand, petitioner is praying to the court for exercise the power under Article 226 of the Constitution, an attempt to avoid the statutory forum. Mr. JT, counsel for the opposite party, he relied upon a decision of this court on 29/7/21 in writ petition 12584 of 2021, contended that for the view of the Honorable Single Judge, the appeal shall lie. Mr. Jettil and counsel of the opposite party contend that the writ petition in the circumstances is not entertainable at all. Considering the rival contention of the parties, this court finds undisputedly there is commencement of section 18 proceeding of the Act on the complaint being made by the opposite party number 1 and a reference arising out of it. For the relevance of provision of section 18 of the Act, the court takes note of provision at section 18, subsection 1, 2, 3 of the Act, section 18, my lord. But this is important, my lord. Notwithstanding anything contained in any other law for the time being in force, any party to a dispute may, with regard to any amount due under section 17, make reference to the Micro and Small Enterprise Facilitation Council. 2, on receipt of the reference of subsection 1, the council shall either itself conduct conciliation in the matter or seeking assistance of any institution or center providing alternative dispute resolution service by making a reference to such an institutional center for conducting counsel, and the provision of section 65 to 81 of the Arbitration Conciliation Act shall apply to such dispute as if the conciliation was initiated under Part 3 of the Act. That is Arbitration Act. 3 says, where the conciliation initiated in subsection 2 is not successful, stands terminated without any settlement between the parties, the council shall either take itself the dispute for arbitration or refer it to institution or center providing alternative dispute resolution service for such arbitration, and the provision of the Arbitration and Conciliation Act shall then apply to the dispute as if the arbitration was in pursuance to an arbitration agreement referred to in subsection 1 of section 7 of the Act. It is regarding reading through the aforesaid provision, this court finds the undisputed fact involved therein, reference being made to a complaint of the petitioner has been undertaken in a conciliation process under the provision of subsection 1, 2 of section 18 of the Act by the council. There is further disclosure through the impugned order that there has been failure of conciliation through the proceeding dated 30/12/2020. Looking at the question framed therein, taking into account the provision of subsection 3 of the Act, also taking note thereof, above, this court finds one statute provides a specific procedure, that is, after the conciliation, failure report is submitted without any settlement between the parties and involves an unsuccessful attempt, the council shall either take itself of the dispute for arbitration or refer it to institution or center providing alternative dispute resolution for such arbitration, and in such event, the provision of the Act shall come into play. Here, looking at the impugned order by Annexes 4, this court finds that the council has made the following observation. But the entire award has not been quoted. The last portion has been quoted by Honorable Single Judge. Both the parties were present before the council in its 84th sitting. Sir, 84th sitting doesn't mean total 84 sittings has been held in the proceeding. The council sits in different dates to take up different matter. This is the 84th sitting of the council. MSME held on 30/12/2020. The petitioner submits that he has supplied the materials to opposite party since 2016, but the opposite party has made part payment, leaving balance rupees 30 lakhs along with interest as per MSME Act 2006. Council observed that so many hearings has been made on 16/11/2019, 19/2/2020, 28/8/2020, 24/9/2020, 30/12/2020, in which opposite party was present on 25/6/2020, 28/2020, 24/9/2020, 30/12/2020. The petitioner submits that conciliation process with the opposite party was terminated without any settlement as per section 18 of the Act. But the conciliations terminated much prior to that. But if you kindly keep, Honorable Court feels this is the date on which the conciliation failed. Actually, conciliation failed much before. Also, after that, the counter has been filed. And then counter submitted by the parties. It is found that the claim of the petitioner is genuine and decided award. The awarding portion has been made. But if your lordship takes to the findings at page 24, thereafter, next page. Reading through the above, there is no doubt that both parties were noticed to attend 84th sitting on 31/12/2020. but further goes to make it clear that conciliation attempted failed in the 84th sitting. That's not correct. Conciliation never failed on the 84th sitting. Court has taken note of the failure much prior to that. That is exactly the case here. And this court finds surprise that when the statute says after conciliation fails and the proceeding is taken up as a dispute, then the only option available to the council either itself to take up the dispute for arbitration or refer it to any institution or center providing alternative dispute resolution service. And again, if the dispute is undertaken by the council itself, same is to be undertaken following the provisions of Arbitration Act. This court here finds the council observing that is failure in conciliation has straightaway jumped to the award. With due respect, this is not the case. I'll show your lordship the award. Therefore, there is no following of section 83 of the Act. Thus, not only the proceeding by Annex 4 is bad, but also subsequent proceeding arising out of involved in Annex 4 is also stands terminated. At this stage, the court takes up the contents of the Mahapatra, but then it takes up the merit of the case and eventually comes to a conclusion that it should be remitted back. Sir, my respected Swami Lordship, kindly have a look at the provision of law first. I'll take your lordship to the statute itself. Or initially, before the Micro, Small, Medium Enterprise Development Act 2006 came into force, your lordship is aware of the fact that previously the interest on delayed payment to small-scale industry and ancillary undertakings Act 1993 was in force. 2006, this act was enacted. But this
dispute relates to this.
This act. Dispute relates to this act. No. Dispute relates to this act. So kindly turn to section. Sir? But section, this is a micro industry, registered on the industries, Director of Industries. But if your lordship looks to section 15, I'll not take your definition part because I have no dispute about it.
Yes.
It says liability of buyer, any supplier supplies any goods or renders any service to any buyer, the buyer shall make payment thereof on or before the date agreed on between him and the supplier in writing, or where there is no agreement in this behalf before the appointed date. Provided that no case the period agreed between the supplier and the buyer in writing shall exceed 45 days from the day of acceptance or the day of deemed acceptance. Section 16 says, date from which the rate at which interest is payable, where any buyer fails to make the payment of the amount to the supplier as required on section 15, the buyer shall, notwithstanding anything contained in any agreement between the buyer and the supplier or in any law for the time in force, be liable to pay compound interest with monthly rates to the supplier on that amount from the time of appointed day, or as the case may be, from the date immediately following the date agreed upon at 3 times of the bank rate notified by the Reserve Bank. 17 says about the recovery. It says for any goods supplied or service rendered by the supplier, the buyer shall be liable to pay the amount with interest as provided in section 16. 18 is a reference, my lord, to the Facilitation Council. Notwithstanding anything, the non-obstantive clause is there, my lord, here. Notwithstanding anything contained in any other law for the time in force, any party to a dispute may, with regard to any amount due under section 17, make a reference to the Micro Small Enterprise Facilitation Council. 2 says, on receipt of the reference in subsection 1, the council shall either itself conduct facilitation in the matter or seek assistance of any institution or center providing alternative dispute resolution service by making reference to such an institution or center for conducting counsel. I have read it, my lord, therefore I am not reading it again.
You were reading subsection 2.
Sir, I am reading subsection 2.
2 does not refer to conciliation, it refers to mediation.
Sir, subsection 2 speaks about conciliation.
Section 2 of section 18.
No, 18.
18.
18.
It says mediation, not conciliation.
Sir, may I just read it again?
Yes.
On receipt of a reference on subsection 1, the council shall either itself conduct conciliation.
Here it is mediation.
No, this provision has been substituted in 2023. This section 18 has been substituted in 2023.
23.
So this matter. 22. So the footnote conciliation in the matter. Yes.
But the Honorable Single Judge also quoted that. Quote is,
footnote it is there. In the footnote, the prior position is there.
Right.
This matter, this transaction relates to prior to 2023.
Prior to.
That's why there is a confusion.
That has also been quoted by Honorable Single Judge. 18.2.
So now it is mediation.
Mediation, right. But it has changed in right. But we are concerned about the conciliation.
This has been streamlined according to Mediation Act 2023.
Right. I'm sorry, I'm reading the old.
Right.
On receipt of a reference on subsection 1, the council shall either itself conduct conciliation in the matter or seek the assistance of any institution or center providing alternative dispute resolution service by making a reference to such an institution or center for conducting conciliation, and the provision of sections 65 to 81 of the Arbitration and Concession Act shall apply to such dispute as if conciliation was initiated under part 3 of the Act. But before I go to 3, let me take your lordships to section 65 of the Arbitration Act. So in that book also, the relevant provisions of the statute is there.
No, footnote. It is there.
No, it is there in a separate heading also.
Oh.
It is there in that book. Your Lordship is holding that book.
Yes.
There, I think, in page 36 or 37, it is there.
The relevant provisions have been put.
Relevant provisions of statutes referred by Arbitration and Conciliation Act 1996. It starts from section 7. In that book, it is there, Manad.
Yes.
If you are free, you can, I can refer to this. This is arbitration.
Okay.
You can use this. You can have this. You can have this. I'll refer.
Yes.
No, I have got the Arbitration Act also, if Your Lordship wants.
Yes, we have.
It is. 65 says, the conciliator upon his appointment may request each party, but here the conciliation facilitation council is the conciliator. Right? Upon his appointment may request either party to submit him the brief written statement describing the general nature of the dispute and the points at issue.
This book is not 65.
Arbitration Act
Nowadays, printers devil. Sadhina dekhi thili.
Yes, please read section 65 there.
65 is there.
Please read.
Nahi hai.
The conciliator, upon his appointment, may request each party to submit to him a brief written statement describing the general nature of the dispute and the points at issue. Each party shall send a copy of such statement to the other party. The conciliator may request each party to submit him a further written statement of his position and the facts and grounds in support thereof, the supplemented by documents, other evidence that may party deem appropriate. The party shall send copy of such statement, document, and other evidence to the opposite party, other party. At any stage of the conciliation proceeding, the conciliator may request the party to submit to him such additional information as he deemed appropriate. Explanation says that in this case section and all the provision section of this part, the term conciliator applies to sole conciliator, 2 or 3 conciliator as the case may be. Consider the bound by certain enactment, not bound by CPC or Indian Evidence Act. Role of conciliator, section 67 says, conciliators shall assist the party in an independent and impartial manner in their attempt to reach an amicable settlement of their dispute. The conciliator shall be guided by the principle of objectivity, fairness, and justice, giving consideration to, among things, the right and obligation of the parties to usage the trade concerned, circumstances surrounding the dispute, including the previous business practices between the parties. 3 says, conciliator may conduct the conciliation proceeding in such a manner as he considered appropriate, taking into account the circumstance of the case, the wishes of the parties may express, including the request of the parties that conciliators will hear oral statement and need for any speedy settlement of the dispute. Conciliator may at any stage of the conciliation proceeding make proposal for settlement of the dispute. Such proposal need not be in writing, need not be accompanied by a statement of the reason thereof. Then if Lordship turns to communication between the parties, conciliator may, in section 69, conciliator may invite parties to meet him or may communicate him with orally or in writing as they meet, or communicate such parties together with each other, them separately. Unless the parties have agreed upon the place where the meeting of so and so, that's not required. Disclosure of information is 70. Then 71 says cooperation of the parties with the conciliator. 72 is suggestion of the parties for settlement of dispute. And 73 is settlement of agreement. If they settle, agreement will be executed. But if your Lordship looks at the provision of the Arbitration Act, kindly have a look at, I've given that act also.
Yeah.
Section 16 of the Arbitration Act. So kindly turn to section 16 of the Arbitration Act. So I'm not reading in detail. 16 speaks about that competence of the arbitration tribunal to rule its own jurisdiction regarding maintainability, or it doesn't have the jurisdiction, inherent lack of jurisdiction. All those points can be raised before the arbitrator itself, who functions as the arbitrator. Section 19, let's say kindly turn. Determination of rules of procedure. It says, arbitration tribunal shall not be bound by the courts. Subject to this part, parties are free to agree on the procedure to be followed by the arbitration tribunal in conducting the proceeding. Failing any agreement, referred to in subsection 2, the arbitral tribunal may, subject to this part, conduct the proceeding in the manner it considers appropriate. Power of the arbitral tribunal under subsection 3 includes the power to determine the admissibility, relevance, materiality, way of any evidence. But then let's say kindly turn to section 24. Section 24 of the Arbitration Act says, unless otherwise agreed by the parties, the arbitral tribunal shall decide whether to hold oral hearing of the presentation of evidence or for oral argument, or whether the proceedings shall be conducted on the basis of document or other materials. So parties may decide, or the arbitrator may decide on the basis of the materials on record itself. But then your lordship turn to page section 31. This will come into picture. Relevance is there. Form and contents of the arbitral award. What an award shall contain? Arbitral award shall be made in writing, shall be signed by the member of the tribunal for the purpose of subsection 1. Arbitral proceeding with more than one arbitrator. The signature of the majority of all the members of the arbitral tribunal shall be sufficient to so long as the reason for the omitting signature is stated, shall state the reason upon which it is based, unless the parties agree that no reason to be given otherwise. And 34 is the provision to challenge the award. Recourse to the court against an arbitral award may be made only by an application for setting aside such award in accordance with subsection 2 and subsection 3. These are the grounds of challenge. Well, let's kindly have a look at section 18, subsection 3 of the Act now. Subsection 3, Malad, where the conciliation, Yeah. Where the conciliation initiated under subsection 2 is not successful and stands terminated without any settlement between the parties, the council shall either itself take up the dispute for arbitration or refer it to the institution or center provided alternate dispute resolution service for such arbitration, and the provision of the Arbitration Act shall then apply to the disputes as if the arbitration was in pursuance to an arbitration agreement referred to in subsection 1 of section 7 of the Act. 4 says, then he functions as an arbitrator. 7.4 says, notwithstanding anything contained in any other law for the time in force. Well, this is a non-obstantive clause again incorporated. The Micro and Small Enterprise Facilitation Council or the center providing alternate dispute resolution service shall have jurisdiction to act as an arbitrator or conciliator under this section in a dispute between the supplier located within its jurisdiction or buyer located anywhere in India. If 5 says every reference made under this section shall be decided within the period of 90 days from the date of making such a reference. Period is also fixed 90 days. But in the Arbitration Act, the period is 1 year, 6 months. The pleadings should be completed within 6 months, then 1 year, within 1 year. But 19 is very important, Malad. Section 19. No application, kindly mark, Malad, no application for setting aside any decree, award, or any order made either by the council itself or by any institution or center providing alternative dispute resolution service to which a reference is made by the council shall be entertained. Or entertained has been defined in section 1968 Supreme Court, admit to consider by any court unless the appellant, not being a supplier, has deposited with its 75% of the amount in terms of the decree, award, or as the case may be, the other order in the manner described directed by such court. Provided that the pending disposal of the application to set aside the decree, award, or order, the court shall order that such percentage of amount deposited shall be paid to the supplier as it considers reasonable under the circumstance of the case, subject to such condition as if deemed necessary to impose. But section 24, let's me kindly have a look at. There's an overriding effect. The provisions of section 15 to 23 shall have effect notwithstanding anything inconsistent therewith contained in any other law for the timing in force. So overriding effect. This provision has to be made applicable. Well, therefore, my first contention is that that REIT application is not maintainable because the party has to challenge the award. But the award has been passed. A detailed reasoned award has been passed. One has to challenge the maintainability or jurisdictional part, any part of it, on section 34, related with section 19. But one has to challenge it before the authority on section 34 itself. Section 19 says mandatory requirement to deposit 75%. To overcome that deposit part, the party cannot be allowed to approach the REIT court to challenge the award itself. But even in arbitrations also, you know, say the SBP case and other series of cases where they say when the provision of section 34 is available, a party cannot be allowed in REIT jurisdiction to interfere with the award. That's taking the provision of law is expressly provided in the statute itself. But now I will take your lordships to award that has been passed, and I'll take you to the decisions which supports my case, my lord. But if your lordship kindly look at, read right on. But copy of the entire award is available in the REIT file at page 113.
No, the grounds which were taken.
Right, my lord.
In the writ petition.
Right.
To assail the award.
Yes.
Whether those grounds were available for him to challenge under section 34.
Yes, my lord, absolutely. And 34, my lord. Your lordship looks at 34. Now we have to see 34. But very much, your lordship is absolutely correct. That's it.
By them they can.
Yes, my lord. I'm conscious of it, my lord. Your lordship is absolutely correct. I bow down to your lordship, my lord. It was my duty to bring your lordship notice. I could not, my lord. Sir, kindly have a look at section 34. Subsection 2, my lord, because it says recourse to the court against an arbitral award may be made only by an application for setting aside award in accordance with subsection 2 and subsection 3. Let's be kindly look at section 34, subsection 2. Section 34, subsection 2, clause 3. The party making the application was not given proper notice of appointment of an arbitrator or of the arbitral proceeding, or was otherwise unable to present his case. His case is that otherwise unable to present his case. Their case was conciliation failed, then award was passed. He was not given the chance to defend his case. Am I clear, my lord?
Yes.
Such a question can also be raised under section 34. But here, opportunity was given the file counter. I'll show your lordship. Kindly look at in the, I don't know whether the REIT file must have come to your lordship, my lord. Page 113, my lord. Yes, 113. That is the order sheet, MSME number so-and-so. Following members were present. Well, got it, well, it is there. History of the case. At the bottom of it, Malad, in the first page. It says the petitioner Tulsi Modern Rice Mills, so-and-so, is a micro industry bearing UAM number so-and-so. For producing raw rice, the respondent delivered paddy to the claimant at his paddy purchase center. Shall be transported and kept in the claimant for storing milling of the paddy and delivery of the customs milling rice to FCI at the designated place during 2016. According the petitioner raised the bill is part of the OP made part payment, leaving a balance of 30 lakhs. The petitioner filed the claim application for the MSME on 1/6/2019, claiming total amount of 51 lakhs 96,000 so-and-so. That is principal with interest. The claim application was forwarded to the opposite party with his office note on 27/9/2019 to file counter, but the same was not received. Counter filed subsequently. The petitioner never disclosed that he is a registered micro so-and-so. That is the objection of the opposite party. Meetings on 2N of the MSME Act. The registration certificate was never produced by before the collector Kendrapada for registering his name as a customs milling. Now, no identity status was disclosed before the OPP, opposite party, while entering the agreement. Opposite party, so the case is not maintainable in the council. It says the petitioner was one of the registered miller. The council of the district opposite parties choose to appoint petitioner as one of the custom miller. The paddy under the detailed terms and conditions as mentioned in the agreement during Kharif season 15-16. Petitioner took delivery of 21,000 metric tons of paddy to the opposite party on signing 18 notes of acceptance note. That the principal secretary FNC department held a meeting on 5/12/16, present in the MD opposite party, Odisha State Civil Supply Corporation. That meeting, the petitioner took part. He has not received 21,000 metric ton, but received 13,787.83.66 metric ton. He gave his written statement to that effect on 5/12/16, undertaking to deliver the rest by so-and-so. Then the petitioner was admittedly liable to deliver so-and-so. Then the strong dispute that the petitioner is entitled to receive 30 lakhs from opposite party towards outstanding dues. As per clause 9 of the agreement executed between the parties, he had deposited the interest-free secured deposit of 33 lakhs at the time of executing the agreement, which was liable to be forfeited in case of violation of the terms and conditions. That failure to deliver a resultant rice balance so-and-so, the petitioner was liable to pay the cost thereof, and he was liable to pay 91,000 odd with 1% interest around 28/2/2017, after adjusting 10 lakhs so-and-so received by invoking bank guarantee, entitled to receive 81 lakhs 57,000 from the petitioner. It would be pertinent to state that petitioner had given 3 checks in favor of opposite party, amounting to 80.72 lakhs towards his liability. But when presented, all the checks were dishonored and the petitioner was marked insufficient fund. Petitioner grossly violated the terms and conditions agreement, disclosure agreement so-and-so, so-and-so. Petitioner received the stored paddy from the opposite party. The allegation that he has received any goods from the opposite party shall not cause him any payment is not relevant and acceptable. This case is not at all maintainable and opposite party is not liable to pay any amount to the petitioner, since the amount of loss sustained by the opposite party due to default of the petitioner is carrying out the obligation of the agreement is more than the amount legitimate received from the agreement. Petitioner is a party in the arbitration case 1/2017 involving dispute arising out of the agreement, which fact has deliberately suppressed the petitioner. He has also suppressed the fact that the case that negotiable instrument act is pending in the court of JMFC Paralakemundi, Patamundai, much before the petition is filed. The petitioner have admitted liability to the extent of so-and-so. A rejoinder has also been filed, Malad. This evidence from made in paragraph 1 by the opposite party, the petitioner is not submitted. So detailed objection has also been raised and contention has been raised. But para 3, that guideline laid down government clearly mentions that at the end of day miller will transit pass come acceptance notes shall be consolidated. For the maintenance of account, paddy shall deliver to the miller against target allotted to essays, but there have no paddy account number so and so on the basis of the government guideline. So the guideline is Annexure 4. Paragraph 7, my lord, can you see of that order? When each party and the opposite party made claim on each other, the matter was taken to the government and cooperative department. Government instructed collector Kendrapada, para 7, my lord.
Page.
Page 118.
Just. Yes, which paragraph?
7, my lord.
7. Both the
When
petitioner.
both petitioner and opposite party made claim on each other, the matter was taken up to government in cooperation department. Instruction to the collector Kendrapada to resolve the case after hearing both parties. The collector CSO Kendrapada filed letter dated 24/2/18, 27/2/18, request of the managing director Markfeld to submit authenticated document to paddy rice note to prove dues pending with the miller. Tulsiram, but till date they could not submit those documents since they have no account note of quintal 13,783. So without account note, the claim of 13,783 is purely illegal. These letters of the collector and Kendrapada annexed to Annexure 7 series. So their counterclaim is also not acceptable. The statement made by the opposite party petitioner issued 3 number of checks. So and so these checks are issued as per government guideline. The manager PP filed letter so and so asked me to pay the paddy when issue 3 numbers of PTO checks as my secure deposit with the receiver letter. This letter reveals that they received the check on 14/6/16 and the circumstances of issuance of check after completion of CMR without returning those are misutilized and filed NI Act case. James Patamunde when we challenged illegality of Markfeld. But each one of their case has been negative also by filing documents to show that their claim doesn't justify. But page 119, last paragraph, my lord. If you are the under part, I have also given. Council wanted to know the status of the claim petition and its outstanding from the claimant. The claimant submitted before the council that they are the registered vendor of Odisha State Cooperative Marketing Federation to a supply of rice out of paddy supply by the Markfeld. The cost of the service charges have been fixed by the government in terms of quantity of rice to be supplied against the quantity of paddy received from the government. Since opposite party was absent, its present position could not be ascertained. It was directed to the council that till finalization of the MSME should carry out their usual business with the petitioner as usual without taking the coercive action. Activities of Ms. Tulsi Mutton Rice Mill should not be affected. During the Kharif marketing season 2019 and 20, the opposite party shall cooperate with the petitioner to run the business activity. Simultaneously, petitioner is to keep his healthy business relations with them. Case was adjourned to 17/1/2020. Kindly mark, this is much prior to the date on which the order has been passed. The history of the dates court has mentioned also. 17/1/2020 for hearing. Due to some exigencies, 78th sitting MSME was deferred to 19/2. Petitioner was present, but opposite party was absent on 78th sitting held on 19/2/2020. Petitioner submitted to the council that unit is in financial crunch due to huge amount of money lying with the opposite party. Council wants to serve the notice to managing director to enable him to present the process of adjudication next date. Then case was adjourned to 22/4/2020. Due to COVID, 79th sitting was deferred. Both parties were noticed to attend 70th sitting to be held on 25/6/2020. Both the parties were present in the 79th sitting on 25/2/2020. Petitioner submitted with the council that unit is financial crunch, use amount so and so. There is no dispute on behalf of opposite party regarding claim of the petitioner. The learned advocate for the opposite files time petition, praying 2 months' time to file the counter. That means they say that question of consideration doesn't arise. I have to file a counter to the claim. The counter was filed thereafter, adjourned to 28/2020. Then, sir, both parties have noticed to attend on 80th sitting on MSME to be held on 28/20 through video conferencing. Both parties are present on 80th sitting on 20/28 and 20. Counsel was filed by the counter was filed by opposition on 19/8/2020 at 5:30. So they called upon to file the counter because they could not settle the matter amongst themselves. Then the court again sitting was adjourned for final hearing. Both parties have issued notice to attend the 86th meeting. Both parties are present for the council in the 82nd meeting held on 24. The petition submitted as advocate is still praying. Again, the time was given. Both parties issued notice to attend 84th sitting on 30th. This is for final hearing, the day on which the final hearing took place. And final hearing, the court has heard, if you have discussed everything, and then passed the award. Because the hearing has taken place number of dates. But my respective submission here will be, if your lordship looks at the law on the subject, it is not that court has not taken up the matter for hearing and he has passed the award. Not that the arbiters, the counter was given, they were not given a chance to file counter and rejoinder and decided the matter. Not that immediately after conciliation failed, they decided the matter. It's not a case of that nature. So this has to be challenged to find out threadbare, the detailed factual aspect on section 34. If it comes within 34, that he has not been given a chance of defending his case. This is not a case whether after conciliation the order has been passed. Law says if the statute provides.
Yes.
Sir, I would like to take your lordships to a few decisions on the subject itself.
No, one decision is there on record. That is in case of
Jharkhand Orissa.
Your lordship is referred to Jharkhand Urja Nigam. Yes, my lord, I'm coming to that. Kind of have a look at, I have given that, I think I had given another bunch I am giving just now. I'll take your lordship to all the decisions, my lord. The recent decision, latest decision in 2024 also I'll give. Yes.
Computer page 254.
I would say, I was arguing one of the matter here that the decision which has been also, I don't know whether it has been referred to or not.
what happened?
They are actually, the award was challenged on the technical ground that the MSME Act is not applicable. It's not a micro or a small enterprise. And the Honorable High Court entertained it, saying, our division bench, my lord, that is not a MSME Act is not applicable. Therefore, we did not ask them to file an appeal. The Act is not applicable. That's why they're all, your lordship, interfering in the matter. Referring to this, Jharkhand Urja. But Jharkhand Urja, if your lordship looks at, he did not take any action. If your lordship kindly have a look at that decision, my lord. At page 4, inner page 4 of that memo of citation.
Jharkhand Urja, I think it says that if conciliation fails, the facilitator has to take onto itself.
He himself
or
becomes the
send
arbitrator.
it to.
Here, same thing has happened
That is the
here.
interpretation of section 18(2)(3).
No separate proceeding is to be initiated. Same proceeding, but he functions as the arbitrator.
He can, the council may refer to
the
arbitrator,
yes.
or may take upon itself.
Right.
The,
Absolutely correct. Absolutely correct. But actually, the Arbitration Act says a conciliator cannot become an arbitrator. The Supreme Court had decided no. This is a special statute referring to section 24, overriding effect. So he can himself become an arbitrator. That has been heard. I'll also cite that decision. But if your lordship looks at Jharkhand Urja case,
No, but whether mediator can become arbitrator, that's all right. That is not the question involved in this case. But mediator cannot be an arbitrator.
So here the Supreme Court has said,
No, that's a different thing.
because the statute
that
provides
question
that.
may arise later.
Because the statute provides that, right?
The statute provides. Mediator can never become an arbitrator.
The mediator should not actually.
Should not.
Should not, right? Because he is hearing both parties, and here actually the conciliator in this case, he is not
Conciliator
exactly
has a
hearing.
different role.
Yes.
No, the distinction between mediator and arbitration.
Asking the parties to resolve.
Distinction between role of mediator and arbitration has already also been discussed by Honorable Supreme Court.
And the distinction between mediator and conciliator.
Different.
It's a different function, different approach towards the.
With due respect, my lord, once the amendment has come into force by referring to mediation, then they should also amend the subclause 3 and 4. But he cannot act as the arbitrator.
Yes, so let us see.
Let us, my lord, if you also can kindly come to 2021 volume 19 SCC 206. Jharkhand Urja.
Yes, 2021.
Right. Sir, kindly have a look at
Volume 9 SCC.
Yes, 2021, volume 19 SCC.
May I privilege I find a written note of submission. I enclose that judgment that is there.
And I am giving just now.
Right, let him.
I have given just now. So kindly look at paragraph 2 first, which is important. Why this case, their lordships interfere in the matter. The appellant herein, which is a successor company of erstwhile Jharkhand State Electricity Board, entered into a contract with third respondent, Mrs. Anamika Conductor Limited, Jaipur, for supply of AC as a Zebra conductor. Respondent number 3, claiming to be a small-scale industry, has approached the Rajasthan Micro and Small Enterprise Facilitator Council, claiming an amount of 74,74,041 towards principal amount of bill and an amount of 91,59,709 towards interest, on the ground that the appellant has not responded to earlier notices. But here the reason for which interference came is this. On the ground that the appellant has not responded to earlier notices, the council issued summons dated 18/7/2012 for appearance of the appellant before the council on 6/8/2012. Only on the ground that on 6/8/2012, appellant has not appeared, the order dated 6/8/2012 was passed by the council, directing appellant to make the payment to the third respondent as claimed within a period of 30 days. Here, no proceeding was done. In the Jharkhand Urja case, he has not adopted to any of the procedure of 18. No conciliation, no arbitration. The said order was challenged in the High Court by writ jurisdiction. Same was dismissed. Other single judge and the inter-court appeal preferred by the appellant was also ended in dismissal. Hence this appeal. We have heard Mr. Anup Kumar and senior counsel appearing on the appellant, Mr. Dinesh Sangvi, Manish Sanvi, senior counsel appearing to the second respondent, the Kailash Yadav, Jaswasdev, and senior counsel appearing on the respondent. Having heard the counsel, the parties, we peruse the impugned order, other material placed on record. It is merely contended that as there was some dispute and the supply was made with the third respondent, the bill amount was not to be paid immediately. It was submitted that only on the ground that appellant has not responded to the conciliation proceeding, straight away the order was passed by the council without giving proper opportunity. The order implementing the writ jurisdiction was passed in utter disregard to the mandatory provision of Section 18 of the Micro and Small Enterprise Development Act and the provision of Arbitration Act. It is submitted that even after the order passed by the council, the appellant, after inspecting the record, has paid an amount of so-and-so through third party respondent. Such amount was paid after inspecting the records to the third respondent, who has received that amount without protest after period of 3 years, and thereafter the third respondent has filed execution case before the civil court Ranchi, which ultimately ended in dismissal on the ground of maintainability. When the said order was challenged by the court in writ court, the writ court was subsequently dismissed as withdrawn. It is submitted when the conciliation fails, as per section 83 of the MSME Act, has to initiate arbitration proceeding. On failure conciliation, the council shall itself take up the dispute for arbitration or refer to any institution or center providing alternative dispute resolution service for such arbitration, and the provision of the Arbitration Conciliation Act shall apply to the dispute as if the arbitration was in pursuance to an arbitration agreement referred to in subsection 1 of section 7 of the Act. It is submitted that in this case, without following the procedure, straight away the order impugned in the writ court was passed, petition was passed without giving an opportunity to the appellant to participate in the arbitration proceeding. But here the fact was entirely different. The law is well settled, madam. Here also correctly stated, conciliation proceeding, then it should made an attempt, then arbitration, then the award. But here in the instant case, nothing happened. Notice, he didn't respond, immediately award has been passed. It was deprecated. The Honorable Supreme Court also referring to the submissions eventually held, if you'll also kindly turn to paragraph 14, 15 and till 18. From reading of section 8, paragraph 14, let us kindly turn to. From a reading of section 18 to 18.3 of MSME Act, it's clear that council is obliged to conduct conciliation for which the provision of section 65 to 81 of the Act would apply, as if the conciliation was initiated under part 3 of the Act. Under section 18.3, when the conciliation fails and stands terminated, the dispute between the parties can be resolved by arbitration. The council is empowered either to take up the arbitration on its own or to refer the arbitration proceeding to any institution as specified in the said section. The claim has to be proved before the arbitrator, if necessary by adducing evidence, even through rules of the Civil Procedure Code, which may not apply, unless otherwise agreed. Oral hearing are to be held. Initiate arbitration proceeding in accordance with the relevant provisions of the Act. The order dated 6/8 is a nullity and runs contrary not only to the provisions of the MSME Act, but contrary to the provisions of the Arbitration Act. The order is therefore patently illegal. That is how the Honorable Court interfered, madam. But here in this case, it is not a case that no proceeding has been initiated. It is not a case attempt has not been made for settlement. It is not a case that hearing has not taken place in the arbitration proceeding, because the date of hearing has been fixed to 84th sitting, and the parties were heard on that day. The day on which the order has been passed, detailed order has been passed, parties were present and they were heard. And the order has been passed, awarding person is the operative person. But therefore it cannot be said it is illegal and it's...
No, the difference between your case and
this case
of Jharkhand Urja is
right,
that there the award was passed on the very day when conciliation was taken up.
No, the parties did not appear for conciliation.
Yes, when the conciliation was taken up and the parties were not there. Therefore, the award was passed on the very day.
Right.
So, in that background, the Supreme Court says that if maximum, the conciliator, the council could have held that conciliation has failed and proceed for the arbitration.
Correct.
In that background, the decision was made.
This was made. But apart from this judgment, which is factually entirely different, all judgments till today speak about that you should approach the under section 34 and section 19, and you cannot obviate to and avoid deposit of 75%. To circumvent the process, not to deposit, you cannot do that. But I'll take leave of your lordship to refer to some judgments, my lord. So there are numbers Supreme Court judgments, but I want to refer the latest decision of the this Honorable Court, Delhi High Court Division Bench. Can I just take your permission to cite it, my lord?
Yes, please.
It has taken note to different Supreme Court decisions also. That is, it was delivered on 8/2/2024.
Yes.
Yes. So the second memo of citation, page 131.
Which you have given today.
Yes, I have given another one.
Yes.
Page 31. So kindly turn to paragraph 5, Malad. There also in paragraph 4, last sentence, Malad. Paragraph 4, last sentence.
Yes.
The appellant contends that the award is non-est in law, deserved to be set aside on the ground of lack of inherent jurisdiction. Paragraph 5, the grounds of challenge. Appellant contends that since at the time of execution of the contract, the time of conclusion of the supply in 1991, respect to was not registered on the MSME Act, in which itself was enacted in 2006. Therefore, the said act is not applicable to the transaction contract entered between the enactment. Then kindly sir turn to page paragraph 6.1. The appellant cites a single judge judgment in Malani Construction Company versus Delhi International Arbitration Center had entertained a petition filed under Article 227 of the Constitution challenging the reference to arbitration made by Micro and Small Enterprise Facilitator Council. He states the writ petition was entertained in reference to arbitration made, MSME was not set aside, or was set aside. This court has considered the submission of the appellant and perused the record. We are considered opinion that writ petition filed with the appellant under 226/2000 for setting aside the award was not maintainable, and the learned single judge rightly dismissed the writ petition. Issue of non-maintainability of the petition filed with the Article 226, para 9, Malad. Para 9.
Yes.
Issue of non-maintainability of petition filed under Article 226/227 of the Constitution with respect to proceeding arising out of proceeding under the Act is no longer res integra. Undoubtedly, Supreme Court in Deep Industries, I have also filed that decision before Lordship, I'll refer if Lordship want, has observed that power of the High Court under Article 226/227 has remained unaffected by the said Act 96. However, this Arbitration Act, however, the said judgment Supreme Court has further held that High Court should be extremely circumspect interfering with the arbitral proceeding in exercise of the said jurisdiction. In fact, Constitution Bench of the Supreme Court in 7 judges bench in SBP Co versus Patel Engineering, I have also filed that judgment before Lordship, has expressly disapproved the practice of High Court in entertaining writ petition under Article 226/227 of the Constitution against the order passed by the High Court arbitral proceeding. Similarly, with respect to the non-maintainability of the writ petition challenging the award passed in pursuance to arbitration proceeding initiated under MSME Act, Supreme Court in the recent decision dated 6th November 2023 in Civil Appeal number 7491/23 title versus India Glycol Limited and another Micro Small Facility Council has unequivocally held that petition filed under Article 226/227 under MSME Act of the Constitution ought not to entertain in view of Section 18 of the Act, which provides for a recourse to statutory remedy for challenging the award in Section 34 of the Act. The Supreme Court has observed that entertaining a petition under Article 226/227 in order to obviate compliance with the requirement of pre-deposit under Section 19 would defeat the object and purpose of the special enactment. That was decided on 6th November 2023, which has been legislated upon by the Parliament. The relevant extract of the said judgment reads as under, that is that India Glycols Limited, this on 28th October 2021, Facilitation Council decreed the claim of the principal sum of so-and-so on which interest and monthly rates 3 times as bank rate prevailing on the date of award was granted on section 16 of the Act till the final payment. The award of the Federal Council was challenged in a petition under Article 226, 227 of the Constitution. By judgment and order dated 14 September 22, a single judge of the High Court of Telangana allowed the writ petition set aside the award on the ground that claim was barred by limitation. The appellant failed to avail the remedy under section 34. If it were to do so, it would have required to deposit 75% of the decretal amount. This obligation under the statute was sought to be obviated by taking recourse to jurisdiction in Article 226, 227 of the Constitution. This was clearly impermissible. For the above reason, we are of the agreed view of the division bench of the High Court that writ petition which was issued to the petitioner was not maintainable. Paragraph 14 again, Mr. Parag P. Tripathi, Senior Counsel, appearing on behalf of the appellant, sought to urge that view of Facilitation Council to the effect that provision of Limitation Act have no application, which has been affirmed by the division bench of the impugned judgment, suffers from a perversity, and hence petition Article 226 is maintainable. We cannot accept this submission by the simple reason that Section 18 of the MSME Act provides for recourse to a statutory remedy for challenging an award on under the 96 Act. However, recourse to remedy is subject to discipline of compliance of the provision of Section 19. The entertaining a petition under Section 226, 227 in order to obviate compliance of the requirement of pre-deposit under Section 19 would defeat the object and purpose of the special enactment which has been legislated by the Parliament. For the above reason, we affirm the decision of the division bench, holding that it was justified in coming to the conclusion that petition under Article 226, 227 of the Constitution issued the appellant was not maintainable. Hence, it was unnecessary the High Court to have come to a conclusion that petition not maintainable and entered on the merit of the controversy which arose before the Council. But paragraph 11, further, the Constitutional Bench of the Supreme Court in SBP Co., while considering the issue interference, the order passed by the arbitral tribunal under Article 226, 227 of the Constitution laid down in para 45 and 46, they have quoted Mallard. But I have also filed that judgment before the Lordship, but I'm quoting the para 45. It is seen that some high courts have proceeded on the basis that the order passed by the arbitral tribunal.
You are referring to which case?
Page 11 of that Delhi judgment, Mallard. It has been quoted, Mallard.
Page 11.
Yes, para 11, page
No,
136.
you are referring to SBP.
SBP, exactly.
Yes, paragraphs 45 and
45 and 46.
Yes.
It is seen that some high courts have proceeded on the basis that any order passed by an arbitral tribunal during arbitration would be capable of being challenged in Article 226, 227 of the Constitution. We saw no warrant for such an approach. Section 37 makes certain orders of arbitration tribunal applicable. Under Section 34, the aggrieved party has an avenue of ventilating his grievance against the award, including any in-between order that might have passed by the arbitral tribunal acting on Section 16 of the Act. The jurisdiction part also can be challenged. The party aggrieved by an order of the arbitral tribunal, unless has a right of appeal under Section 37, has to wait until the award is passed by the tribunal. This appears to be a scheme of the Act. The arbitral tribunal is therefore, after all, a creature of the contract between the parties. The arbitration agreement, even though if the occasion arises, the Chief Justice may constitute it based on the contract between the parties. But that would not alter the status of the arbitral tribunal. It will still be a forum chosen by the parties by agreement. We therefore disapprove of the stand adopted by some high courts that any order passed by the tribunal is capable of being corrected by the High Court under Article 226, 227. Such an intervention by the High Court is not permissible. 46 para says, object of minimizing judicial intervention while the matter is in process of being arbitrated upon will certainly be defeated if the High Court could be approached under Article 227 or 226 of the Constitution against every order made by the tribunal. Therefore, it is necessary to indicate that once the arbitration has commenced in the arbitral tribunal, parties have to wait until the award is pronounced. But paragraph 12, let me kindly see. With respect to objection raised by the appellant to the effect that MSME Act doesn't have inherent jurisdiction to make a reference to arbitration under the provision of MSME Act, therefore a writ petition would be maintainable, it is misconceived. Similar fact in Supreme Court in Gujarat State Civil Supply Corporation in Mahakali Food Limited, 2023, volume 6, SCC, page 401. I have also filed that decision before Lordship. I have given that compilation. Such an issue of lack of inherent jurisdiction can be decided by the arbitrary tribunal appointed under this said Act by virtue of section 18(3) of the MSME Act is competent to rule its own jurisdiction. Is competent to rule its own jurisdiction by virtue of section 18(3) of the MSME Act. This sequitur is that the decision of the arbitral tribunal on the issue of jurisdiction would be amenable to challenge on section 34 of the Act. In the light of the aforesaid judgment of the Supreme Court, para 13, more specifically the judgment of Indira Glycol Limited, MSME Malkangiri, we are of the considered opinion that judgment of the only single judge in Malan Construction Company, or the previous paragraph, the single judge judgment was referred to, that he has set aside the award. Holding that the writ petition 226 Constitution can be maintainable is not the correct view. They have also deprecated referring to Supreme Court view itself. But here the other parts are not required. Only one thing I would like to say, the mandatory nature of section 19, paragraph 14, last portion, the mandatory nature of section 19 of MSME Act has been pronounced upon by the Supreme Court in Gujarat State Disaster Management Authority versus Aska Equipment Limited. The same cannot be circumvented by the petitioner by filing the present petition. The petitioner admittedly has sufficient annual income so-and-so and cannot be deposited in errors which can be raised before the competent court in terms of the observation by the Supreme Court. So this mandatory nature also requires to be deposited, but that cannot be obviated.
Yes.
But this also refers to several decisions which I have brought to your Lordship's notice. But I would like to refer to that Indira Glycol Limited, India Glycol Limited, just 2 paragraphs. Because that was the recent decision of the Supreme Court.
Where is that?
That is at page 55 of the first memo of citation.
55. Yes. Glyco.
Yes, sir. India Glycols.
Yes. Yes.
The paragraph, I'll just take your Lordships to paragraph 6 actually. Here also division bench held that it is not maintainable. Then it was challenged, my lord. Paragraph 6, my lord. In Delhi, the judgment it was also quoted, my lord.
Yes.
This judgment has been delivered on 6th November 2023.
Yes.
Having held that the petition was not maintainable, the High Court has nonetheless inquired into whether the claim was barred by limitation, come to the conclusion, following the decision of Gujarat State Civil Supply Corporation Limited and Mahakali Food Private Limited and another, that the claim was time-barred. We have heard Mr. Parag, Senior Parag Tripathi, Senior Counsel appearing on behalf of the appellant, Dr. S. Murlidhar, Senior Counsel appearing on behalf of the second respondent. But incidentally, Dr. S. Murlidhar
Yes.
was the Chief Justice here, my lord.
That will make no difference.
No.
Yes.
Then paragraph 9, there section 19 has been quoted. And paragraph 10, if your lordship looks at it.
Yes.
Terms of section 19, an application for setting aside award of the Facilitating Council cannot be entertained by any court unless appellant has deposited 75% of the amount in terms of the award. In view of the provision of section 18(4) of where the Facilitating Council proceeds to arbitrate upon the dispute, the provision of the Act 1996 have to be applied. It is as if it's in pursuance of the arbitration agreement on section 1 of section 7. And the remedy which provides on section 34 of the Act 96 govern an award of Facilitation Council. However, there is a super added condition which is imposed by section 19 of the Act to the effect that an application for setting as an award can be entertained only upon appellant depositing before the council 75% of the amount in terms of the award. Section 19 has been introduced as a measure of security for enterprises for whom a special provision is made under the MSME Act by the Parliament. In view of the provision of section 18(4), the appellant has remedy on section 34 of the Act to challenge the award which it failed to pursue. The judgment of this court in Gujarat State Civil Supply Corporation, a two-judge bench of the court, observed that the proceeding before the Facilitating Council, acting as arbitrator tribunal under section 18(3), would be governed by the Arbitration Act. And para 12 says, appellant failed to avail the remedy on section 34. If it were to do so, it would have been required to deposit 75% of the decretal amount. This obligation under the statute was sought to be obviated by taking recourse to jurisdiction on Article 226, 227 of the Constitution, and this was clearly impermissible. Then paragraph 14, last sentence, if you I don't want to read the entire thing again.
Paragraph 17 is important.
Paragraph 14, last portion.
All right.
The entertaining a petition under Article 226, 227 in order to obviate compliance with the requirement of pre-deposit would defeat the object and purpose of the special enactment which has been legislated on by the Parliament. This is a three-judges bench of Honorable Chief Justice Chandrachud.
Yes.
Delivered on 11 November, Merit.
Yes.
You'll also kindly turn to this requirement of 75% deposit by another Delhi judgment, referring to Supreme Court judgment, of course. The State Gujarat Disaster Management Authority. The second memo of compilation, page 139.
Yes.
With the Lordship's permission, this is a single judge judgment, Merit.
Yes.
The reason for citing this judgment is that, if you also kindly see, paragraph 4, Merit. Paragraph 3 to onwards, Merit. I'll read the relevant portions, Merit. He further states that terms of section 19 of the Act, petitioner required to deposit 75% of the award amount at the time of filing of the petition. In case the same is not done, it is non-est filing of in the eye of law. Court cannot grant time to make the pre-deposit on section 34 of the Act. In the present case, in view of the award dated 23/9/22, the last date of deposit so and so, since the same has not been deposited now, petition liable to be dismissed. He has referred to some judgments. Then eventually, but in paragraph 13 says, 13, in view of the filing and entertaining a petition are two different aspects. Here I am the view that there is no bar in filing a petition in section 34 of the Act. Same can be filed without pre-deposit of the award. However, the said petition will not be entertained without deposit of 75% of the awarded amount. But this has been referred to, that I was telling before Lordship, or submitting for Lordship, that 68 Supreme Court, they have referred to, admit to consider that paragraph 12, their Lordships have decided it. That section 19 of the MSME Act categorically use the word entertain, para 12 of the state judgment. The word entertain has been explained in Lakshmi Ratan Engineering Works versus CST in 1968, volume 1, SCR 505, which reads as under. with the word entertain, which is there in section 19. To begin with, it must be noticed that the proviso merely requires that appeal shall not be entertained unless it is accompanied by a satisfactory proof the payment of the amount of tax admitted by the appellant to be due. A question thus arises: what is the meaning of the word entertain in this context? Does it mean that no appeal shall be received or filed, or does it mean that no appeal shall be admitted or heard and disposed of unless satisfactory proof is availed? The dictionary meaning of the word entertain was brought to our notice by the parties. Both parties agree that it means either to deal with or to admit to consideration. We also are of the same opinion. The question, therefore, is that at what stage can an appeal be said to be entertained for the purpose of application of proviso? It is entertained when it is filed, or it is entertained when it is admitted, or the date fixed for hearing, or it is finally entertained when it is heard and disposed of. Numerous cases exist in the case law.
Yes. Please.
No party to dispute with regard to any amount under Section 17 of the MSME Act would be precluded from making reference to MSME facilitation council through an independent arbitration agreement exists between parties. Because in this case also, there was an arbitration clause. They were taking a ground that the arbitration proceeding is going on, therefore you cannot come. The facilitation council, which has initiated conciliation proceeding, would be entitled to act as an arbitrator, despite bar contained in Section 80 of the Arbitration Act. The proceeding before the Facilitation Council Institution Center as an arbitrator under Section 18(3) would be governed by Arbitration Act 65 to 81. The Facilitation Council, acting as an arbitral tribunal by virtue of Section 18(3), would be competent to rule its own jurisdiction, also other issues in Section 16 of the Act. A party who was not a supplier of the so-and-so on the date of entertaining the contract cannot seek any benefit as a supplier under the MSME Act. If the registration is obtained subsequently, the same would have an effect of prospectively, would apply to supply of goods entering subsequent to the registration. Then you'll see kindly look to paragraph 48. 48 nahi yaad hai.
Yes.
Sorry, extreme sorry.
Para 48 must be somewhere at page 97 or 98.
One second. Just 1 second. I'm sorry.
It ends with para 36. The judgment ends with para 36.
No, the SCC, AIR paragraphs must be different.
No, is it different? I'm bringing it to your notice. Now, say, first again, to our original data. Go through and data.
No, because you have given citation of AIR and you have given copies of Manupatra. Therefore,
Yes,
this difference in the paragraph.
There's a discrepancy with regard to page and paragraph followed.
So when you are placing paragraph 34, you wanted to place something else, but because that was there in paragraph 31, therefore you placed that.
Right. Because yesterday night actually it was by my friend.
Happens.
That is the latest Supreme Court judgment. Very like that. Legal position is clear. Basis of at page 12 for the first memo of citation.
Yes. Yes.
Silk industry, if your lordship looks at paragraph 23.
So it is always safe to rely on either SCC or AIR. The moment you this thing.
Manupatra actually creates problems sometimes.
Manupatra is good for Manupatra only, but yes, because paragraphs change.
Right. Para 23, if you looks at para. In the first compilation, my lord.
Yes, yes. We are having.
The obligation of the buyer. Para 23, at page 23, the obligation of the buyer to make payment and award of interest at 3 times the bank rate notified to the Reserve Bank in the event of delay of the buyer and the mechanism of recovery and reference to micro small enterprise facilities in council. The further remedy under 2006 Act, the party agreed by the award are covered by Chapter 5 2006 Act. The provision of section 15 to 23 of the Act are given overriding effect, notwithstanding anything inconsistent with the contained in Indian law for the timing in force. From the statement of object and reasons, also it is clear that
the conclusion, Mr. Mishra, is at the bottom.
Yes.
Thus we hold.
Thus we hold that MSME Act, being a special statute, will have the overriding effect. Besides the Arbitration Conciliation Act, which is General Act, even if there is an arbitration agreement between the parties, the resolution of the dispute of arbitration, the seller is covered by Micro, Small and Medium Enterprise Development Act. The seller can certainly approach the competent authority to make its claim. If an agreement between the parties is there, the same is to be ignored in view of the statutory obligation and mechanism provided under the 2006 Act. Further, apart from the provision of section 23(2)(a), it is to be noticed that counterclaim is not permitted. Buyer can get in the legislative or the compound interest of 3 times of the bank rate and the 75 deposit contemplated under section 6 to 19. For the aforesaid reason and the harmonious construction of section 18(3) of 2006 Act and 7(1) and 23(2) of the 96 Act, we are of the view that counterclaim is maintainable before the statutory authority under the MSME Act. They have also held that. But that has got overriding effect. That is one of the basic structure. But in Punjab State Power Corporation, paragraph 1 to 6, if your lordship kindly turn to page 1.
Which one?
Page 1, my lord, same citation list.
Yes. Yes.
Only in case of patent lack of.
Patent lack of, inherent lack of jurisdiction.
Then only 226 or
226.
7 will come into play.
Right.
Otherwise,
Actually, the court should not interfere because there is a special statute provide for it.
para 5.
Para 5. The mechanism is there.
Deep industry case.
It also refers to deep industries. Do not suffer from patent lack of inherent jurisdiction. This is one of them. Instead of dismissing the writ petition on the ground of statute, High Court would have done well to have referred the judgment of deep industries and dismiss the Article 227 petition on the ground that there is no such perversity in the order which leads to patent lack of inherent jurisdiction.
Only in case of exceptional circumstances.
Right.
Yes.
But the distance I cited before Lordship is 2022, Supreme Court 1932, Tirupati Steel versus Subha Industries. But why I cite this distance? Because they say the same thing. But all those decisions have been passed even after the judgment that I have referred to, that Jharkhand Urja. These decisions have come thereafter.
No, Jharkhand Odisha is
Jharkhand different.
Jharkhand is different. Jharkhand Urja is different.
Exactly. My respectful submission of Lordship is that that's the only decision which says that if you have not done anything, you have to do all these things. But in all these cases, I'm citing for Lordship, even that Tirupati Steel versus Subha Industries at page 66 of the second citation list, page 66.
Yes. Second list.
That is decided on 19/4/2022.
Yes.
This is MR Shah's judgment. If you Lordship kindly look at paragraph 7 to 11. 7 to 11 kya hai idhar?
Yes.
That is again of
No.
11 would do.
Okay.
Paragraph 11 will do.
Sir, paragraph, if Lordship kindly turn to.
In view of the above, considering the language.
In view of the above decision of the court, the impugned order passed by the High Court permitting proceedings in 34, while insistence of deposit of the award is unsustainable, so it will deserve to cost.
We are happening at 75%.
75%.
That is 9.2 and para 11.
Yes, madam.
On a plain and fair reading of section 19 of MSME Act, reproduced herein above at the time before entertaining the application for setting aside the award made under section 34 of the Arbitration and Conciliation Act, the applicant or appellant has to deposit 75% of the amount in terms of award as a pre-deposit.
Okay. That Mason Electric
Even
is,
hardship will not come to rescue.
okay,
That is what
that's
you may be. 9.2.
right. Page 100, if your lordship looks at Mason's Electrical Industry, that's the Allahabad High Court judgment. Page 100. The division bench judgment. Parag. It also speaks about the overriding effect and the mandatory requirement of 75% deposit. Referring to Silpi Industries and Gujarat State Supply Corporation, Mahakali Foods Private Limited.
Yes.
Para 47.
Para 47,
121.
conclusion.
Page 121.
Yes, my lord. Page 121. C says, as per section 32 of the MSME Act, that overriding effect, my lord. While repealing 93 Act, it made clear that anything done or any act undertaken by 93 Act shall be deemed to have taken by MSME Act. The application filed by the appellant before the Facility Council is deemed to be under this new Act. The Honorable Supreme Court in Silpi Industries has held that MSME being a special act will be overriding effect of 93 Act. It further held that if there is any agreement between the parties, the same shall be ignored in view of the statutory obligation and mechanism provided under the MSME Act.
Yes. So all these provisions are in the background of the objects to be achieved.
Yes. Background of the object is to be achieved.
And those objects we can see from the can come to E, F, G, and H of paragraph 2 of the preamble.
Yes, but judgment that has been referred to. Madam.
The judgment has been referred to. No, we are referring to the Act.
Act, Madam.
MSME Act. Preamble.
MSME Act.
MSME Act, if you also looks at section 24 is the overriding effect.
No, we are referring to why these enactments were made. What was the requirement of enacting the
law, Madam. The preamble of the Act itself says, Madam.
Preamble E, F, G, H.
A statement of objection.
Yes. It is small scale industries at present defined as notification of section 11B of the industry.
Come to 2 E, F, G, H.
To provide statutory definition of small enterprise, provide establishment national board and so, provide classification of micro, empower central government to notify program.
No, please come to, yes.
This is provision for ensuring timely and smooth flow of credit to.
Yes. So this was one of the objects.
One of the objects,
75%.
Making provision for ensuring timely and small flow of credit to small and medium enterprise to minimize incident of sickness, enhancing the competitiveness of the enterprise. Empower the central government, notify reference and so. So E is one of the main object, the reason for which this act was enacted.
And H and G. H, make further improvements in the interest on delayed payments to a small industry. So the object was this.
Making that enactment a part of the proposed legislation to repeal the.
And therefore there is a requirement that you pay 75%
right, deposit. Not to lead you to sickness. The outstanding due remains as such. And therefore the interest part is in a special, they mentioned compound interest with monthly rest. But to summarize actually the entire case itself, if your lordship looks at, reference was made, admittedly 30 lakhs was due, and they wanted to make a counter claim saying that outstandings are there with me. They could not file any document before the authority, like the Conciliation Council. And the Conciliation Council heard on the last day of hearing. They referred to all previous dates of hearing and the proceeding that has taken place, and eventually arrived at a conclusion that award is this. So it is not a case that conciliation fails and award has been passed. So the Honorable Single Judge, while dealing with the matter, has referred to two last paragraphs, saying as if on that day the conciliation failed. That was the argument advanced by the other side, petitioner. That conciliation failed on that day and the award has been passed. It is not a case of that.
Yes. Thank you, Mr. Mishra.
Now it is 4 o'clock.
Yes, so what?
Man, 4 o'clock in the time is not the thing. My learned senior has given me 2 sets of judgments just now.
The judgments, in fact, are not required to be supplied in
But if
advance.
that is so, I can jot it down in my own.
The question is very simple. There is provision for there is an award passed by the arbitrator, the council, as an arbitrator. There is provision for challenge under the Arbitration Act. The High Court has entertained the writ petition. There are several judgments that the High Court should not have entertained the writ petition. That is the only question.
No, matters. With due humility, matters. The case is something different. I am to refer to pleadings in respect of that and the proposition of law. Then, I will refer to that decision and the law laid down by Honorable Supreme Court, what to be followed, how the procedure to be followed, and whether it has been followed or not.
So that you can say, tell the court.
No, matters. Fact means is not that. Question is, matters, only I will point, my learned senior pointed out detail of the facts, pleadings and all these things. What has been taken care of in so far conciliation proceeding is concerned. The conciliation matters, the law matters, before matters entering into all these matters, factual aspects matters, may I submit one thing. Fact remains kind of a glance to section 18. What is the mandate of section 18 matter?
Yes.
One is that suppose I am a MSME unit. I have a claim against the party. So I am to apply it to the concerned authority. Means the council. That is one. 2 minutes. On receipt of the reference, means whatever complaint petition they have given, under subsection 1, the council shall either itself conduct conciliation in the matter or seek the assistance of any institution or center providing alternative dispute resolution service by making a reference to such an institution or center for conducting conciliation, and the provision of section 65 to 81 of the Arbitration and Conciliation Act shall apply to such a dispute as if the conciliation was initiated under part 3 of this act. My humble contention is this, matters. There is a reference. He claimed some benefit. But before that, matters some background concerning the dispute. The background is this Markfed is a government of India undertaking, government of Orissa undertaking. It undertakes custom milling operation. The custom milling operation matters, I think it is there everywhere in every state. Thing is that different the paddy processing units are there. The Markfed will collect to avoid distress sale of paddy. The Markfed will collect matters on payment matters will collect the paddy from the farmers. They will give it, it will give it to the concerned party. The concerned party will process it, convert it to custom milling rice. Then it will supply it to the store. And in between whatever amount due is entitled to get it. In this case, what has happened? All of the procurement paddy was given to the company. This the now present appellant. It is a paddy processing unit. This appellant, the officers went there, found those paddies which were supplied to him missing. There was no such paddy available there. That is why criminal proceedings were initiated. Then there was an assessment. and this assessment, there was a demand, you return that money. You have not processed the paddy, you return that money. And whatever paddy you processed and converted to rice and you given it, let us calculate it and decide it, whatever the amount due, and the rest amount you return to us. This is what is the thing. In between, Commissioner come Secretary, Mayorship, Food and Civil Supply, convened both, called both, then decided that yes, this is the amount, this is the amount you have to pay. Means the present appellant is to pay to the market. Market could not get it. So for the purpose, it has got blacklisted. Till date, it is unable to participate in customary paddy procurement. Paddy procurement means this paddy procurement, but the paddy means.
How is that relevant for this proceeding?
But I'm coming to that. Just I'm taking some time. My learned senior has stated little fact. That is what it is required. That is what I saw submitted it. Fact remains. Then there are the disputes insofar that agreement is concerned. There are some disputes. That is going on in a different forum. That is a different thing. While matter stood thus, he filed a petition stating that I am entitled to 30 lakhs. That is what? As if conciliation comes when there is an arbitration and we agree. But fact remains, the conciliation, during conciliation, I disputed it, and that the disputes are going on. It is throughout during conciliation. All during these periods, conciliation process taken up, some pleadings were there. These pleadings are in between that conciliation period. Ultimately, what has happened? The conciliation failed. Then, minors, I am pointing out that part. My learned senior read all these things, but one line, minors, how this council dealt with this. How council, if council has dealt with as if it is an adjudicated an arbitration, claim, counterclaim, rejoinder, the way my learned senior has submitted, thing would be different. That also cannot be made possible because in absence of a conciliation, there cannot be jumping into the arbitration directly. There must be an arbitration. Sorry, my lords, there must be a conciliation. So how the council has come to a conclusion, and thereafter how they have dealt with about the arbitration part. That will feature that features the
So whether this aspect can be gone into under section 34 or not?
But 34 it cannot be. But fact remains, if I will be going to 34, then question is that part can be gone into or cannot be gone into. That relates to fact and all these things. But here in this case, I say, but referring to this Honorable Supreme Court law laid down by Honorable Supreme Court.
That's not the question. The question is, whatever you are submitting, whether those submissions could have been made by you in a proceeding under section 34 or not.
Minus 30, right, minus pointed out that whether section 34 in the sense referred to in 19. My humble contention, it can be gone into 34. I can also prefer the writ petition on the ground that injustice has been caused to me because I am deprived of a total procedure. But this is a clear departure of the procedure under 18.3. That is what my humble submission throughout. I am now referring to this portion.
Yes.
My learned senior read it. I am reading my lords.
Yes. Which part?
The conciliation of that conciliation which is constituted as an arbitration. According to me, it cannot be an award. Cannot be termed as an award. Cannot be treated as an award.
Then don't challenge. Why did you challenge? If that was not an award, that was nothing.
They went on treating as an award. But to me, this is not an award. It cannot be an award. It cannot be passed.
Right.
That is what we have come and preferred writ petition. What is
Where is the provision for execution?
Execution under 34 that is under Arbitration and Conciliation Act. Now it is under Commercial Court Act.
So you could have said that there is no award.
No, that there we have stated. But fact remains, my lords, once they treated
who treats an award? Who is treating? According to you, that was not an award. Ignore that.
But they can, but the executing court, my lords, they would be the knows about the limitation. They cannot beyond go beyond the award.
You could have told the executing court that's not an award.
We may tell it before the executing court, but fact remains, executing court will decide whether it is an award or not. But question is that they cannot go beyond the award past because they are bound by that.
Still, if you can understand, your client can understand that this is not an award, the court shall also be in a position to understand that it is not an award which can be executed.
I'm kindly bear with me for 1 minute, my lords. One page that starts from the office order which culminated in an award, office order of the council culminated in an award that starts.
Where are you reading?
Page 113.
113 of?
It starts from page 113 of the, it is probably read petition matters.
Yes, which annexure?
Read petition, that is page
Read
113.
petition.
Annexure 4.
Yes.
Matters. There, my lords, the first history of the court, history of the case, then my lords counter, my learned senior pointed out, thereafter the agenda, they say, the last portion, operating portion. That is at page 121. I think Miles got it, man.
Yes.
Page 121. Last paragraph. Both the case was adjourned to 24/9/2020 for final hearing. Both parties have issued with notice attending such and such. Both parties, that is not required, my lords. Both parties are present before the conciliation meeting held on 30th December 2020. The petitioner submitted that he has supplied the material to opposite party.
So what is the date of this award?
The date of this award is 30th December 2020.
Yes.
Because that is under signature page 122.
Yes, yes.
Last paragraph. The council observed that, how the council had dealt with it, observed that so many hearings have been made on such and such date. The party submitted that the conciliation process with OP was terminated without any settlement as per section 18(2) of the MSME Act 2006. The council perused the claim petition and counter submitted by both the parties. It is found that the claim of the petitioner was genuine and decided to make the award as follows. Then there is no reason, nothing. They pass that order. Now, in this context, I am reading my 18.8, section 18(3). Well, this makes it very clear that conciliation failed, arbitration award passed. Well, there is no reasoning, well, whatever pleading, whatever that is there. But all that means in between conciliation period. Thereafter, all of have suddenly jumped into an hour. Well, then, kind of a class to 18.8. After 18.2, if conciliation fails, what happens? Well, 18.3. May I read minutes?
Yes.
Where the conciliation initiated under subsection 2 is not successful and stands terminated without any settlement between the parties, the council shall either itself take up the dispute for arbitration, then arbitration begins from that, or refer it to any institution or center providing alternative dispute resolution services for such arbitration and provision of the arbitration and conciliation 1996. So my humble contention that the conciliation failed on that date. Thereafter, arbitration process begins because this will be coming within the province of the Arbitration and Conciliation Act. There I am to be given an opportunity of filing objection written statement to the claim, counterclaim also, then evidences. Both parties should be given opportunity of hearing. Thereafter, there will be an hour. Not that whatever discussed during conciliation will constitute an hour, will be a ground to constitute an hour. That is what my humble contention. But fact remains, 18.3 is sacrosanct. 18.3 is being violated here in this case, has not been adopted at all. That is what I am referring to, my written note of submission. My written note of submission.
Yes, please, please.
That is Jharkhand, my learned senior read it. Jharkhand has no application. But my humble contention, this Jharkhand Urja Nigam case, what has happened is there was a conciliation failed, somebody has not participated, then ultimately leading to an award, and that award can be passed.
That was not the case in Jharkhand Urja. Jharkhand Urja conciliation proceeding has started, and in the conciliation proceeding, the party did not appear, and soon thereafter the order was passed.
But I am not disputing on that. But the law point laid down balance there. Honorable Supreme Court laid down the procedure referring to 18.2 and 18.3. My lords, that is what, my lords, I'm submitting. I'm not going to the other aspects, my lords. My lords, paragraph 8. Right or wrong, there is an award, my lords. Now, Honorable High Court discussed about, Honorable Supreme Court discussed about this and how to follow them.
Please.
Alright, only on the ground that even after receipt of the summon, the appellant has not appeared, the council has passed the order award on 6/8/2012. But let us consider that there is an award. As per section 18(3) of the MSME Act, if conciliation is not successful, the said proceeding stands terminated, and thereafter the council is empowered to take up the dispute for arbitration on its own and refer to any other institution. The said section itself makes it clear that when the arbitration is initiated, all the provisions of the Arbitration Council 1996 will apply, as if arbitration was in pursuance of an arbitration agreement referred to under subsection 1 of section 7 of the Act.
Yes.
Section 18 minutes. Section 18(1) quoted, 18(2) quoted, 18(3) from then para 9.
Yes.
From reading of section 18(2) and 18(3) of the MSME Act, it is clear that the council is obliged to conduct conciliation, for which provision of section 65 to 81 of the Arbitration and Conciliation Act would apply, as if the conciliation was initiated under part 3 of the said act. Thereafter, madam, under section 18(3, when the conciliation fails and stands terminated, the very important thing is here in this case it is failed.
Yes.
The dispute between the party can be resolved by arbitration. The council is empowered either to take up the arbitration on its own or to refer the arbitration proceeding to any other institution as specified in the said section. It is open to the council to arbitrate and pass an award after following the procedure under relevant provision of the Arbitration and Conciliation Act, particularly section 20, 23, 24, and 25. This must be followed. Other provisions of the Arbitration and Conciliation will follow. So, but here in this case, my humble contention, you concluded, you said that yes, 18(2), this conciliation failed. Then you are to begin the arbitration proceedings, and then to follow this to come to arrive at a conclusion and to pass an award. Well, thereafter, there is a fundamental difference between conciliation and arbitration. In conciliation, the conciliator assists the party to arrive at an amicable settlement in an impartial and independent manner. In arbitration, the arbitrate tribunal, arbitrator adjudicate the dispute between the parties. The claim has to be proved before the arbitrator, if necessary, by adducing evidence, even though the rule of the Civil Procedure Code or Indian Evidence Act may not apply unless otherwise agreed. Oral hearing are to be held. But then, if the appellant has not submitted its reply at the conciliation stage, failed to appear, not submitted or failed to appear, the Facilitation Council at the best have recorded the failure of the conciliation and proceed to initiate arbitration proceeding in accordance with the relevant provision of the Arbitration and Conciliation Act. My humble contention, with due humility, here in this case, there might be a number of debts, but all these were part of the conciliation proceeding. And conciliation proceeding terminated. You have stated that under 18(2), the conciliation proceeding failed. Then arbitration proceeding began. You could have begun that arbitration proceeding. My learned senior has referred to number of decisions. I have not gone through those decisions because this is being given to me. But whatever I read here, 3 contingencies are there. In some cases, arbitration, suppose arbitration under Arbitration and Conciliation Act, some cases, once the award is directly challenged before the Honorable High Court. Well, then Honorable Supreme Court said, unless there is an error apparent on the face of the record, we cannot interfere because 34 is the remedy. It is obvious. I participated. Arbitration proceeding commenced and concluded.
There cannot be such decision.
Well,
there cannot be such decision that on the ground of error apparent on face of record.
I'm submitting my.
All right. Please continue.
Then, the second part is that in some cases, all those cases, MSME Act, there is no culmination of arbitration proceeding following due procedure of law as prescribed under 18(3). Here in this case, there is serious infraction of 18.3. Once there is a serious infraction of 18.3, arbitration proceeding has not commenced. Award followed without any reasoning. without adhering to any reasoning, because of the fact that the conciliation failed, then, my lords, the decision of the Honorable Supreme Court says, this is, my lords, thereafter, my lords, that is paragraph 13, my lords. Paragraph 13, the order dated 6/8/2012 is nullity and runs contrary not only to the provision of MSME Act, but also contrary to various mandatory provision of Arbitration and Conciliation Act 1996. The order dated 6/8/2012 is patently illegal. There is no arbitral award in the eye of law. It is true that under the scheme of the Arbitration and Conciliation Act, an arbitration award can only be questioned by way of an application under 34, what my lords has put me to the question, of the Arbitration and Conciliation Act 1996. At the same time, when an order is passed without recourse to the arbitration and in utter disregard to the provision of the Arbitration and Conciliation Act, Section 34 of the said Act will not apply. That is where there I am standing, my lords. Here in this case, I am standing on the ground that whatever conciliation, after failing of the conciliation, whatever order you have passed, you straightway jumped into that without following this procedure. Whatever Honorable Supreme Court has observed here, you should have followed the procedure, could have passed an hour. Now what is happening, my lords? After that, the council has issued notice, we appear, then we filed counterclaim, awaiting arbitration. Arbitration award will be there within a stipulated time, my lords, because time limit, there is time limit. But thereafter, the award, if award goes against me, obviously I will file it, I'll take recourse of Section 19, which specified that 34, section order Section 34, I am to challenge. Here in this case, Honorable High Court single bench held, you straightway jump from 18.2 to 18.3 on your own and concluded it. That is why it is illegal. They have not closed the chapter here, but quashed it. They remanded the matter for an adjudication. You cooperate. Let us cooperate together. Adjudicate upon. See that it should be confirmed. Here in this case, what is happening is that if it would be treated as 34, then this market, means the government of Orissa company, they would be compelled to pay 75% deposit. That is what all the attempt is. My humble contention where the award is not honest in the eye of law, and the award can award, but now proceeding continues. Suppose the proceeding continues, it's convoluted into an award, then obviously, man, thereafter 34 comes and I'll go and I'll deposit 75% of the amount. So far that arbitration act is concerned, then it is up to the court, up to the concerned the commercial court to decide to stay. Here in this case, the specific amount 75%.
We'll hear you tomorrow because we need to rise for administrative work. Is there any order passed by the council terminating the conciliation proceeding?
Regarding?
Terminating the conciliation proceeding.
The
failure of conciliation. Because that is the language which is used.
Section 18.
18. And stands terminated.
Stands terminated.
So whether that is there or not, we would like to know. That is very crucial.
One line I would like to say. So the Facilitation Council, this is the final order. See, this starts that both parties participated in the hearing. Final order, my lord. While passing before the final order, parties were directed to file counter and rejoinder.
No, the history is mentioned.
Right.
But there must be one stage where conciliation must have terminated because of failure. So whether that is there or not, that is very crucial.
But actually,
only sittings were discussed, and it was getting adjourned due to some.
The order sheet will show, but the order sheet, entire order sheet, I don't have.
Please examine. Please examine. Please tell us tomorrow, because that is the very important.